afternoon to our Honorable Chief Guest, distinguished dignitaries on the dais, respected Director Ma'am, faculty members, and my fellow students. I am Anjana Rajkumar, a student of third year BA LLB, and it's my absolute honor to serve as your Master of Ceremony for this prestigious event, the 18th Annual MedLegal Review 2026. Today's review is organized by the Patil University School of Law in collaboration with the Institute of Medicine and Law, and is proudly supported by the Schools of Medicine, Public Health, and Pharmacy of the Patil University. We are gathered here to explore the vital intersection of law and healthcare, ensuring a future of ethical practice and legal clarity. With the grace of Sadguru Gajanan Maharaj, we are commencing this remarkable event. I humbly request our esteemed dignitaries to join us for the lighting of the lamp ceremony. This tradition symbolizes the ushering in of knowledge and wisdom. Thank you, dignitaries. I request you all to take your respective seats on the dais. It is our distinct privilege to felicitate our Honorable Chief Guest, Justice M.L. Tahalyani, Sir, former Judge of the Bombay High Court and former Lokayukta of the state of Maharashtra. I request our Director, Professor Dr. Karunakshay Malviya Ma'am, to kindly welcome and felicitate our Chief Guest. We are also pleased to welcome and felicitate our guest of honor, Ms. Viveka Roy Chaudhary Ma'am, editor of Express Pharma. I request our director, Professor Dr. Karunakshay Malviya Ma'am, to kindly do the honors. I request our Director Ma'am to kindly felicitate Advocate Mahindra Kumar Bajpai Sir for being an esteemed partner in this journey. Before we begin, we pause to acknowledge the guiding light of our institution, whose unwavering vision and commitment to excellence continue to transform the landscape of education in India. Let me take the absolute honor of introducing the pioneer of education industry, Dr. D.Y. Patil, Sir. Sir has been the former governor of Bihar, Tripura, and West Bengal, and the recipient of the prestigious Padma Shri Award. Dr. D.Y. Patil, Sir, is a well-known educationist and philanthropist. He strongly believed that youth in India needed a greater platform that offered multiple opportunities to educate themselves across geographies. He envisioned the goal of spreading education across the length and breadth of India and started the journey with the first engineering college called Ram Rao Adik Institute of Technology in Navi Mumbai in the year 1983. There has been no turning back since, and the D.Y. Patil Group taking giant leaps in the fields of education, healthcare, and sports under his mentorship. It is my honor to introduce our Honorable Chancellor and President, Dr. Vijay D. Patil, sir. Sir is a visionary leader whose dynamic guidance has shaped the growth of our university. He is an inspiring academician and entrepreneur whose passion for education, sports, and healthcare has transformed the D.Y. Patil University into a premier institution of excellence. His relentless commitment has enabled thousands of students to flourish, while iconic creations like the world-class D.Y. Patil Sports Stadium stands as a testament to his vision and dedication to empowering young India. I'm glad to introduce our Pro-Chancellor and Vice President, Dr. Shivani Vijay D. Patil ma'am, who is a driving force behind many of the university's forward-looking initiatives. Her commitment, creativity, and unwavering support have strengthened the institution at every step. Her graceful yet strong leadership has continually uplifted the morale and confidence of all stakeholders. It's my privilege to introduce our Honorable Vice Chancellor, Dr. Vandana Mishra Chaturvedi ma'am, an accomplished academician with over 23 years of experience, leads the university with vision and precision. Under her guidance, the university has achieved the prestigious NAAC A++ accreditation, expanded international collaborations, and strengthened digital governance. It's a privilege to introduce our director, Professor Dr. Karuna Akshay Malviya ma'am. She is a PhD holder and a UGC Senior Research Fellow. Ma'am is a visionary leader who notably led the first ever Indian academic delegation to the International Court of Justice and the University of Oxford. Beyond her administrative excellence at MNLU Mumbai and D.Y. Patil, she is a certified mediator and a tireless advocate for the rights of women and children. To set the context for today's event, I would like to introduce the School of Law of the D.Y. Patil University. The School of Law is a premier institution dedicated to delivering quality legal education, known for its strong academic foundation, experienced faculty, and modern learning environment. The School of Law focuses on developing skilled, ethical, and socially responsible legal professionals. With practical training through moot courts, legal clinics, and industry interactions, the School of Law continues to shape confident and competent advocates for the future. This event is further enriched through a meaningful collaboration with an institute that stands at the intersection of medicine and law. The Institute of Medicine and Law is India's premier authority on medical jurisprudence, providing doctors and hospitals with real-time actionable legal expertise. From hosting the influential National Conference on Medicine and Law to pioneering the industry standard SOP on patient consent, IML bridges the gap between healthcare and legal system to ensure a safer, more compliant medical practice. The annual MedLegal Review 2026 is a flagship initiative designed to keep the medical and legal fraternities updated on the ever-evolving legal standards and best practices in healthcare. This 18th edition is particularly special as it marks the first major program under the strategic partnership between D.Y. Patil University School of Law and the Institute of Medicine and Law. Our goal today is to examine critical issues such as medical negligence, patient rights, and regulatory compliance. By bringing together doctors, lawyers, and policymakers, we aim to reduce disputes through better legal awareness and promote a healthcare system built on transparency and accountability. As a student of law, I believe today's discussions will be an invaluable addition to our academic journey. I now call upon Mr. Balaji Iyer, sir, from Institute of Medicine and Law to share the opening remarks and brief us on the context of this event.
ladies and gentlemen, namaskar. At the outset, I would like to take this opportunity to extend a very warm welcome to our speakers, esteemed panelists, and our guests for sparing their valuable time and make this year's annual medical legal review. At the same time, I also welcome all the online viewers watching the program live on a beautiful Friday afternoon. It's an honor to have you all here sharing your valuable time and experience. Medicine has always been revered as a noble profession, with doctors often seen as guardians of health and saviors of life. The COVID pandemic starkly reminded us of their dedication and their sacrifices. Yet, we often get caught in a paradox. We defy doctors in times of need only when vilifying them when outcomes are not favorable. This dichotomy highlights the need for a more nuanced understanding of medical practice, one that acknowledges both its trumps and limitations. It is also pertinent to understand that while doctors may have the correct knowledge of medicine, but they are not taught law. Unfortunately for doctors in the healthcare industry, this MedLegal knowledge is also not easily available, although it plays a very critical role in the current scenario where patients have more information readily available and also are more demanding. At the Institute of Medicine and Law, we are committed to empowering healthcare professionals with the knowledge and the tools they need to navigate the complex MedLegal landscape. This knowledge empowers them to practice in a legally safe environment and reduces the possibility of medical errors, thereby ensuring and enhancing patient safety. This also fosters a culture of transparency and accountability. The annual MedLegal review is an attempt in this direction. It analyzes all the judgments over the past 1 year and delivers it to doctors and hospitals in a super crisp, actionable format. It has always been a place for dissecting and understanding the nuances, the shifts, the changes, the trends that shape the MedLegal space. This year will be no different. And today's interesting session will provide you with a unique lens to better understand the evolving landscape of healthcare and law. Some of the critical aspects that we will be covering in the course of this discussion will be emerging trends in medical litigation, shifts in patient expectations and rights, the impact of recent court decisions on healthcare practice, strategies for mitigating medical legal rights. In a vibrant democracy like ours, discussions and deliberations should never stop. No law is perfect, and there is always room for improvement. As we navigate the complexities of healthcare and law, we must also engage in open, informed dialogue, and that is precisely what we are set out to do today. So sit back, relax, and let the gray cells take over. Thank you very much.
Thank you, sir. To set the context for today's review, I invite the chairperson, Professor Dr. Karuna Akshay Malviya ma'am, Director of the School of Law of D.Y. Patil University, to kindly deliver the opening address.
Thank you, Anjana. So it's a good afternoon to everyone. It is a moment of immense pride and profound significance that we have gathered here today at this unique crossroads, a bridge where the clinical precision and the law meets the deep-seated compassion for medicine. As the director of D.Y. Patil University School of Law, I am privileged to welcome you all to this 18th Annual MedLegal Review 2026. I especially welcome Justice M.L. Tahiliani sir for his gracious presence in this gathering as a chief guest. I welcome Ms. Viveka Roy Chaudhary, Editor Express Pharma, as a guest of honor. I welcome Advocate Mahendra Bajpayee ji in this gathering. I also welcome our distinguished panelists, Dr. Suma Nair, Dean for School of Public Health, Dr. Swati Sonavne, HOD, School of Medicine, Dr. Chirag Balian, Associate Professor, School of Law, Dr. Shrikant Shetty, Editor, Medical Law Cases, and our moderator for this panel, Dr. Amit Kumarji. I also welcome our organizing partners, the Institute of Medicine and Law, the office bearers for the same. At the School of Law, we have always believed that legal education cannot exist in vacuum. A lawyer's duty is not merely to interpret statutes, but to understand the human condition they govern. Our core philosophy is rooted in multidisciplinary synergy and holistic development of our students. We believe that solving the challenges of modern society, be it AI-driven diagnosis or complex bioethical dilemma, requires a whole-of-university approach. When the law, medicine, and public health speaks the same language, society wins. This is why we foster a learning environment that integrates classroom theory with fieldwork and collaboration with elite institutions, ensuring our graduates are not just practitioners, but visionary leaders. Today's event marks a historic milestone. On 14 January 2026, School of Law entered into a strategic MOU with the Institute of Medicine and Law. This partnership aims to address the growing challenges of medical negligence, litigations, patient rights, and ethical medical practices. The 18th Annual MedLegal Review 2026 is the first flagship program of our collaboration, but it is only the beginning. Under this MOU, we are currently in the process of launching the National Convention on Medicine and Law, a platform to identify lacunae in the current regulatory framework and suggest remedial measures, Executive Program on Hospital Administration, a specialized training program for hospital leadership to strengthen governance and compliance, and a research on patient charter, an academic endeavor to consolidate patients' right into a coherent, publicly known framework. The objective of this annual review is a rigorous survey of the development in the medico-legal study during 2025. We aim to bridge the communication gap between legal experts and healthcare providers, ensuring the law is not a hurdle for the healer, but a framework that allows healing to happen safely. Today, we delved into two critical issues, one, an enduring challenge, and other, a burgeoning legal transformation. About the first, the enduring challenge, plugging the lacunas in the government scheme, we must address a persistent old issue. Can the misuse of government healthcare schemes be minimized? Despite the implementation of Aadhaar-based eKYC and a biometric authentication, loopholes remain. In 2025, we saw the rejection of over 3.5 lakhs fraudulent crimes worth 643 crore under the schemes like ABPMJ. The issue of ghost billing, upcoding of health packages, identity theft continue to drain public funds. We must ask, why are these loopholes not getting plugged despite AI-based monitoring? Is it a failure of technology or a systematic lack of legal enforcement? Second, the new landmark, empowering the backbone of healthcare, is a transformative shift. The Kerala High Court recently passed a landmark judgment extending a protective guidelines of the Jacob Matthew case to nursing staff. Historically, why were nurses not involved as important in the Indian legal landscape compared to other countries? While countries like UK and Canada have strict patient-to-nurse ratios and high professional autonomy, Indian nurses often battle overwhelming workloads, sometimes attending to 40 beds simultaneously, and face a lack of career specialization. The Kerala High Court has now ruled that nurses like doctors cannot be prosecuted for medical negligence without an independent medical expert opinion. What else can be done? Beyond legal protection, we must ensure moral support, better compensation, and a safe harbor environment so our nursing fraternity can deliver services without the paralyzing fear of malicious prosecution. An event of this magnitude and intellectual depth is not possible in isolation. So this summit thrives because of the holistic support from our entire university ecosystem. I would like to extend my deepest gratitude to our organizing partners, Institute of Medicine and Law, for their unwavering commitment to this cause. Furthermore, I want to thank supportive partners from D.Y. Patil University, School of Medicine, School of Public Health, and School of Pharmacy. Your participation underscores a fundamental truth. Solving the challenges of modern medicine requires a whole-of-university approach. When law, medicine, public health, and pharmacology speaks the same language, society wins. Your presence today signifies that we are not just educating specialists, we are building a collaborative community of professionals dedicated to the sanctity of human life and the rule of law. In conclusion, the goal of this review remains in-depth, rigorous analysis of MedLegal sector. We are here to ensure that as healthcare evolves, the law evolves with it, not as an obstacle, but as a guardian. To our students, I hope today inspires you to look beyond your textbooks and see the human lives evolved by every legal brief you write. Let us engage in this session with an open mind and share a goal of creating a safer, moral, legally sound environment for better human civilization. Thank you.
Our esteemed chief guest, Honorable Justice M.L. Talyani Sir, is a name synonymous with integrity and the relentless pursuit of justice. From his beginnings in Rajasthan to his elevation to the Bombay High Court, his career is a testament to dedication. Sir has presided over some of India's most sensitive cases, most notably serving as the special judge for the 26/11 Mumbai terror attack trial. In a feat of global judicial excellence, he delivered that historic verdict in exactly 1 year. Following his distinguished tenure on the bench, he continued his service to the public as the Lokayukta of the state of Maharashtra. Please join me in a warm welcome for a true titan of the law, Justice M.L. Talyani, sir. Sir, the stage is yours.
No, I can. There's no issue. Small issue. I can. With whom I start, Dr. Karuna Malviya, Mrs. Rai Chaudhary, Mr. Bajpai, and gentlemen, ladies and gentlemen of the dais. For me, this is a really new subject because I had never been a judge of consumer court or never been practicing in consumer court. Of course, I was never a doctor. I was lawyer and judge. And in the course of lawyer and judge, I had occasion to deal with many cases, few of which were dealing with the medical issues. The first ever case in my life I was confronted with, which involved medical issue, was in 1988 when I was a magistrate at Borivali Court, 26th Court. Young magistrate, 1988 means how many years? A case came before me. Old lady filed a complaint against a doctor for negligence. That is, in IPC it was, I think, 338 or something like that. There are two sections, 337 and 338. 338 deals with the grievous negligence. What happened? She was operated for some abdominal issue, maybe uterus or intestine or something like that. I don't remember. But one pipe is used by doctors after the surgery, which is left here for draining. That pipe unfortunately went inside and hole was plugged. I don't know whether it is sutured or it is automatically plugged, but that pipe was inside, this much piece of pipe. After few days or months, she started, complaining pain in the abdomen. She went to some doctors nearby. Doctor prescribed some antispasmodic tablets. Temporarily relieved, but ultimately the pain was not going, so she was advised X-ray. In X-ray, that pipe was found. And she filed a complaint against the doctor who had operated upon her for medical negligence. It was my first ever case. Subject was new. I was new as a magistrate also. So I studied the case in detail and ultimately I issued a summons to the doctor for answering the charge with which he was charged. The doctor went to High Court. I remember Justice Saldana was there in High Court and he quashed my order. So this was for the first time that I came across a case of medical negligence. Thereafter, friends, my emphasis today is on the fact that medical negligence cases are on rise. Why these cases are on rise? Whether there is more medical negligence or whether there is people have become more aware, or whether the judges are liberal to accept those cases, or whether the precedents are such that they are encouraging the people to file medical negligence cases. There are many reasons, but the fact remains that this issue was not, this conduct of doctors was not considered as a medical negligence despite deaths or injuries or something like that before the case of, I think, Santhana or something like that. One case was decided in which it was Supreme Court decided that the medical negligence is cognizable. Thereafter, the case of Jacob came, where it was decided that the medical negligence by itself shall not be a criminal offense unless it is a gross criminal negligence. Thereafter, many cases came one by one from Supreme Court, and ultimately the issue remained that the negligence of the doctor is cognizable. Now today, the issue before us is that what is the solution for this and why it is happening. We must go into the cause of it, and then only you can find out the solution. Like medical or legal issues, unless you diagnose the case properly, you cannot give a treatment properly. Similarly, unless you understand the legal problem of the client, you cannot give him the proper advice. So, this is increasing because there are few doctors, there are few patients, there are few doctors who are really negligent, there are few patients who are taking the doctors for ride unnecessarily. These are two types of cases which are increasing in the court. Doctors who are qualified really, properly, and they are giving proper treatment. If you take the help of judgments of Supreme Court, they cannot be prosecuted. Only because there is a mistake of judgment. Mistake of judgment is not considered as a negligence. Therefore, those who are maintaining ethics, those who are practicing properly, those who are following the procedures which are normally acceptable procedures, even if they commit some mistake, that is not a criminal negligence. That falls under the category of error of judgment, for which you cannot prosecute the doctor. Now, what is happening in our country today, unfortunately, the doctors' degrees are being bought. Now, if I am having a purchased degree, how can you expect me to be an ethical doctor? First, because I have spent money. Ethics, I have gone in Dabba that time only. When I gave money for my admission, I miss my parents. And when I become doctor, my parents expect कि इतना पैसा खर्च किया है तो return किधर से आएगा? They invest something more. They buy some equipments for me so that I can practice. Because my degree is purchased. So my degree is not working, therefore equipments are necessary. The best of the equipments, radiological equipments, nuclear related equipments are given to me by my parents. A first class clinic is open for me. A very renowned person will come, he will inaugurate. This is one category of doctors who are creating problem for the other ethical, honest doctors. There is another category of doctors who are quacks, who are creating problems in the profession. The quackery is too much in our country. It is quacks, particularly in Jhopadpattis. I will not blame them, but to my knowledge, there is majority of doctors in Jhopadpattis. They are quacks. They don't prescribe the medicines, they dispense the medicines. Now, there is no name on the medicine which he is given to you. The practice which they are doing, I tell you, I can also do. After my office hours, I can sit in some jhopdi and I can do practice. I can collect few thousand rupees and go home. Means lawyer come doctor. The knowledge which I have, I don't think that they have more knowledge than that. So with that limited knowledge, if the patient comes and he complains abdominal pain, we will check. Bukhar bhi hai. So what he will give? He will give him some medicines for abdominal pain. Maybe anti-amoebic, metronidazole, tinidazole or something like that. Not very costly, ornidazole and all these things. Then he will give him paracetamol, which is I think 10 paisa per tablet. He will give him anti-allergy, Avil or something like that, which is I think again 5 or 10 paisa per tablet. And if additionally, he may give him Delusil MPS in bottle with some sticker. But nowadays they are prescribing. So these medicines he give on the basis of symptoms. He has not clinically diagnosed the patient, the disease. He has given medicine on the basis of symptoms. Symptoms, of course, you have to take history of the patient and then only you can give clinical diagnosis. But you must give clinical diagnosis whether it is fever due to some infection in the stomach. If you are prescribing ornidazole with fluoxetine, then you must know what is the infection, what may be the probable cause of the pain, and what is the effect of that pain which is there in the abdomen. So simply by because these quacks have now come to know that these puri medicines are not trusted by the people. Therefore, they know some medicines also. If I know in legal profession, why can't they know? So these are two groups of doctors which are causing problem. Now what happens? These quacks are not prosecuted. Once a FIR or something is lodged against the quack shifts like Jhopdi. Now in Bombay, jhopris are being shifted, these quacks are also shifting. Tomorrow, quack will not be available to you. What is happening, those elite doctors who have purchased degree and who have bought equipments for their clinic, these doctors are being prosecuted. And these, along with these doctors, some other good doctors are also becoming victims of the knowledge of the patients. Therefore, the time has come when we have doctors and lawyers, we have to evolve a method. First of all, we have to concentrate ourselves on some issues which are the plague for our professions, legal profession as well as medical profession. First of all, the foremost thing is that we all must be ethical. If you are ethical, other things are secondary for me, according to me. A judge, honest judge, having lesser knowledge of law is better than a good judge having, a corrupt judge having better knowledge of law. Because that corrupt judge will use his knowledge for his benefit, for making money. An honest judge who has little lesser knowledge of law, he will strive hard to understand the problem, and he will someday or other he will become an honest, good judge. But there is no scope for corrupt judge to become honest. It may be a rare case. In our language, rarest of the rare case. If a corrupt person becomes honest, it will be a rarest of the rare case, according to me. Therefore, first thing we must be, our emphasis must be on the ethics. Secondly, for doctors, trust. Your profession is on the trust, based on trust. Patient must trust you. For developing that trust, there must be an informed dialogue with the patient. Those days have gone. When you just prescribe the medicine or give some puddings and patient has gone. And after 3 days again he will come. Patient now today wants to know what has happened to me and what medicines are given to me. Whether these medicines are good for me or not. He will immediately go to ChatGPT or Gemini and find out कि क्या दिया है आपने. Now the medicines, there are some medicines which are broad spectrum according to in your language, antibiotics. Some doctors, what happened, they give a powerful antibiotic कि चलो कुछ भी होगा तो इससे इस antibiotic से ठीक हो जाएगा. What I want to say कि if you have a specific antibiotic for specific disease, please prescribe the specific antibiotic. Don't prescribe broad spectrum antibiotic unnecessarily. If you know that amoxicillin will work on this, don't give more powerful antibiotic for that, because it will work, but it will be more harmful also. If you give antibiotic and you give probiotic also, I don't know whether it is good or bad. There are two philosophies. One philosophy says that you give antibiotic, after few days you give the dose of probiotic. Second philosophy says that you give antibiotic and tell him after half an hour, take probiotic. But doctors, I have seen, they say कि ये एक ये एमोक्सिसिलिन और ये प्रोविडेक दोनों सवेरे, दो दोपहर को, दो रात को. Am I right? Now the two theories are also right. You probably may think कि मैं ज़्यादा लॉ पढ़ता हूँ या मेडिसिन पढ़ता हूँ. मेडिसिन में मेरा थोड़ा इंटरेस्ट है, लेकिन मैं मेडिकल प्रोफेशन में नहीं आना चाहता. नहीं आऊँगा मतलब अभी 73 हो गया है, इसके बाद nobody will. So I don't want to become a quack. So what I say कि there must be informed dialogue between the doctor and the patient. Trust, informed dialogue. These are two important things. Then shared decision making is one thing. Means when you make a decision, you share with him. It is part of trust, part of taking the patient in confidence. And along with that, you must have a compassion for the patient. If you are not compassionate, then you see you are a commercial person. Medical profession is not purely commercial. Money comes with your profession, with your decision, with your prescription, with your hard work. Money is not the motto of your profession. That is what I want to say. I believe that most of you will agree with me that money should not be motto of your life. Money comes. Money is not everything in life. You do what you are assigned to do, money will come to you. There are doctors, you don't get appointment for 2 months. People are running behind them. So money is running behind them. They are not running behind money. You create a situation where money runs behind you, you don't run behind the money. The ultimate analysis is that you should be honest in your profession. There should be a trust, there should be a shared decision making, and ethics should be maintained. Now I have said so many things for you to do, but whether we can do all these things in today's life, there are problems. Technology has so much advanced that people are immediately, you see, I told you about ChatGPT and all these things. So the pressure is too much on the medical profession. With this pressure, maintaining honesty, maintaining ethics, maintaining shared knowledge, whether it is possible or not. To my knowledge, it is possible. I can tell you from my experience that the person who is honest, who has maintained trust with with whom he is dealing, he is more confident, he is more reputed, he is more accepted in the society. If you are more reputed, if you are more accepted in the society, what else do you want? I don't think that you need money in place of reputation and your acceptance in the society. As I told you, money comes. There are many renowned doctors, money is running behind them, but there are many renowned doctors who take money and they take undertable money also. And people tell us कि वो तो नहीं करेगा. जब तक आप 5 लाख रुपए कैश नहीं देंगे तो ओटी में नहीं जाएगा. If this is happening with the doctors, then this is not a good scenario. We have to change it. Time हो जाएगा तो बताना. Now legal profession is also more or less similar to the medical profession. When client comes to me, sometimes you see in your profession, some doctors are involved in some cases falsely or unfortunately or because of some pressure from outside. So you have to sustain all these things while dealing with the patient. But I would say that whatever may be the pressure, whatever may be the problem, honesty, trust, ethics is the first thing. There is no substitute for it. And if these things are with you, you are the most protected person in the society. I tell you one incident. One of the patients dies in the nursing home, and postmortem report says that patient has died due to cardiac arrest. The patient was related to some very, very powerful person. That powerful person thought that the patient had died due to pneumonia. And pneumonia was not diagnosed, no treatment was given for the pneumonia, and therefore she died. So he got a medical board appointed for examining the viscera and all these things, and ultimately medical board also came to the conclusion that the patient had died due to cardiac arrest. This man went to the extent of getting another board appointed, and that board gives an opinion that the patient had died due to pneumonia. Now, if this is happening, where the doctor should go? Now, the doctor in whose nursing home the patient had died, after this opinion, the police has again investigated the case, but police fortunately have come to the conclusion that there is no case against the doctor. Now, they have filed a closure report in the court of magistrate. But that powerful person has filed a protest petition opposing the closure report, that it should not be accepted. And that closure report is pending in the court since last 7 years. And nothing is happening. Now, who should be blamed? Here in this case, according to me, the magistrate should be blamed. He should have courage to decide what is wrong, what is right. Closure report you accept or you reject and take cognizance. So these are the difficulties of the medical profession. With these difficulties, today you will be sitting and you will be discussing all these issues. I hope that your discussion on these issues will bring about some good solution. I would go to the extent of saying that now Supreme Court has said that doctors shall not be prosecuted unless there is an expert opinion. You take expert opinion, because you see, magistrate, police is not qualified. In this case, I told you, police, you see, accepted the, police were honest enough to accept the first report. Now, first basic postmortem report and board report was that the patient had died due to cardiac arrest. The police said, we will not accept the second report, it is manipulated. I would say, I would go to the extent of saying that any criminal negligence complaint against the medical officer shall not be accepted unless a complaint is lodged in the court of competent magistrate by the victim or relative of the victim, close relative of the victim, maybe sister, brother, parents. If such type of amendment comes, the role of police is eliminated. Because you see, police are not expert on this subject. If a person files the complaint in the court, he will go with the expert opinion along with the complaint, and he will be examined in the court. Doctor also will be examined as a witness in the court, and then only the magistrate will decide whether a process should be issued or not. So this, thoda pani. So this, bas, sorry. So this type of short amendment is necessary. If you, during the course of your discussion, discuss on this point, I think that will be fruitful. As far as legal profession's role is concerned in this whole scenario, the legal profession also should be very straightforward, honest, ethical. Because I tell you, if somebody comes to me and there is no case to be filed against the doctor, but I say कि नहीं file करेंगे, ये गलत है ऐसा. Because you see, if I am interested in my professional fees only, then I am likely to give a wrong advice. But if I am interested in the welfare of the client as well as my fees, I don't say that you don't take fees. As I said, कि fees will come. But basically, I must see that my client is protected. I give proper advice to my client. Similarly, when giving advice to the client, particularly against the medical officer, this care should be taken by the legal professionals. For any case, since this conference is on medico-legal, so legal profession is also not free from many issues. The issues which are a plague for your profession are also in the legal profession. There are quacks in the legal profession also. You must have seen black coat persons wandering outside the Esplanade Court. Many of them are not lawyers. They say कि affidavit है क्या, signature है क्या, वगैरह, they call like this. Now this, if outsider comes to Bombay, कि वकीलों की हालत है क्या बम्बई में, कि रोड पर भीख मांग रहे हैं. They have brought a very bad name to the profession. At least in medical profession, the quacks are sitting in one place. In legal profession, quacks are wandering on the road. That is additional merit. Medical, even in legal profession, advice given by the lawyers sometimes is found to be wanting too much. A person comes for advice कि मेरे हाथ से ऐसा हो गया, can I apply for anticipatory bail? No, offense is bailable. Offense is bailable, Mr. Bajpai. It is for your profession. Offense is bailable and says, yes, कल कर देते हैं. He will prepare anticipatory bail application and will file in the court. It is happening or not? Bajpai is not listening. So next day the judge will say, कि Mr. you have filed anticipatory bail application. Anticipatory bail application is entertained only in non-bailable offences because you can be arrested by the police. Cognizable non-bailable offences. This is bailable. Even if you are arrested, police have to release you on bail immediately. Where is the question of anticipatory bail? So then he said, I may be permitted to withdraw. Arre, mister, you should not have applied. Then he comes out of the court and asks the client कि क्या हुआ? कोर्ट ने बोला है कि वो पुलिस अरेस्ट नहीं करेगी, हमने बोल दिया है. A person was convicted of the offense of murder and he was sentenced to life imprisonment. Lawyer comes out of the court, client is uneducated, he follows him. काय झालं? साहेबांनी सांगितलं मोठ्या कोर्टात जा. Means you file appeal. He doesn't tell him that your relative has been convicted. So these wrong practices must stop. In legal profession also ethics are important. Knowledge is again important. If you don't read, if you are not up to date in law, you are bound to commit mistakes. A degree from National Law School is not going to help for legal practice. degree from National School of Law can get you corporate appointment. But if you are interested in legal practice, degree of any law college, with your, urge to practice is sufficient. Most of the Supreme Court judges and High Court judges are BA LLB from simple law colleges. Now, after few years, maybe national law colleges judges you will see, but today's judges are all BA LLB, become LLB, BSc LLB, or BA Honors LLB. From today's Chief Justice is from Haryana. The previous Chief Justice, Mr. B.R. Gavai, he was from Amravati. So what I mean to say is whether it is, I don't want to go into details of many other things because we don't have time. You require time to discuss all these things. I have come only to inaugurate and to persuade you to discuss during the course of this workshop or conference few issues which are haunting legal profession as well as the medical profession. And now, earlier the legal profession and medical profession totally were separate. Now they are interwoven particularly because of this medical negligence cases. I hope that the time may not come when a doctor needs a lawyer by the side of his cabin. There is a doctor-lawyer cabin. First, doctor will go to lawyer ki ye karu ya nahi karu. Whether it will amount to medical negligence or not. So, any error on your part, remember, is not medical negligence. Any honest error, mistake of judgment is not negligence. What has happened due to the change scenario, the doctors are also now scared to give any clinical opinion. They don't give clinical opinion unless you bring the reports. They have a printed form, tick, 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 tick. A report leke aao. After going through the report, he will tell you ki what is the problem. Sonography kara ke aao pet ka. There is no clinical diagnosis after judging your intestine, large and small. Ki whether you have amoebiasis or what, whether the stomach is hard or what, whether your intestines are soft. There could be, the patient is female or male. If the female patient is, there may be problem of uterus, which is not there in male patients. So, clinical diagnosis, doctors are scared because of this situation. Am I right or wrong? Otherwise, earlier people used to write clinical diagnosis. And even if they want to prescribe some test, they will prescribe later on, but they will first write clinical diagnosis. The last thing I want to say, that as far as possible, if we can avoid prescribing medicines to the patients and we can avoid prescribing legal action to the clients and tell them some better options, it is good. If there is a dispute between brothers, we should try to settle them. नहीं इसको तो हम लेके रहेंगे ऐसा करें. Yesterday I had a case between two brothers. One brother has paid full money for the premises. Other brother has possession of the premises. Now the brother who has paid money, he has filed a suit for declaration of ownership and possession. Now this man says, I want to fight with him. Why do you want to fight with him? He has paid the money. He is owner of the premises. He will get declaration. After 20 years, he will get decree. You will have to give possession. You will have to give compensation. You will have to give the lawyer's fees and all these things. So please settle. He is ready to pay you 50%. Today, tomorrow you will not get that. So, you see, this is the honest opinion. If he is giving you 50% of 3 crores, means you will get 1.5 crores today. You want to spend 1.5 crores and after 20 years again pay half a crore. So my sincere request to the lawyers and judges is that particularly doctors, as far as possible, the prescription of medicines freely, as far as you see medical tests are concerned, I am not coming in your way because the clinical diagnosis has become a problem for you, so you people are going for all these tests and all this. But prescription of medicines should be done very carefully. Don't prescribe medicines ki ye nahi to wo kaam karegi. This is not done by all qualified doctors, but this is done by some of the doctors. But when you sit together, you discuss, you have a conference, you have workshops, you tell all the junior doctors, you just don't go on prescribing. And last thing, I had gone to Dr. Kapoor, you must be knowing, O.P. Kapoor, 3 times. He did not prescribe me any medicine. He said कि सब दवाइयाँ बंद कर दो. You don't need all these things. Then I went to Dr. Ramurthy, famous doctor. He wrote something. ये क्या ले रहे हो? क्यों ले रहे हो? कोई जरूरत नहीं है. He wrote, stop all medicines. No medicine is required. I was taking Rentec. He said, why are you taking Rentec? Rentec is acid blocker. You need acid for digestion of your food. If you block acid, how will you digest your food? You will become sick. So these are the issues. There are issues and issues we can go on discussing. Please try to discuss all these serious issues in your conference and try to find out some methods to relieve the patients and clients from unnecessary miseries. That is my sincere request to you, and you have patiently heard me. I did not look to this side while addressing. I am sorry. So, but you were listening, I hope. So you listened me very carefully, silently. I hope that whatever I have said will be accepted by you, and I am very much thankful to Madam for inviting me. I am very much thankful to Mr. Bajpayee, who is very carefully listening me. And I am thankful to all of you for carefully and peacefully listening me. Maybe I might be wrong in some medical things, for which you may forgive me. Thank you very much. Thank you.
Thank you so much, sir, for your valuable insights. Moving forward, I request Professor Sonal Satelkar ma'am, our Professor of Practice, to propose the vote of thanks for the inaugural ceremony.
Good evening, one and all. On behalf of T.Y. Patil, deemed to be University School of Law, I stand here to extend my sincere gratitude to all those who made this inaugural ceremony of the 18th Annual MedLegal Review 2026 possible. First and foremost, my sincere thanks to our chief guest, Honorable Justice M.L. Tehliani, former Justice, Bombay High Court. Thank you, sir, for your time and your valuable insights. Nobody would say you're not a doctor, sir. And sincere gratitude to Ms. Viveka Roy Chaudhary, Editor, Express Pharma, and Advocate Mahendra Bajpai for your time. Thank you, madam. Thank you, sir, for your time. A special word of thanks to our founder, Honorable D.Y. Patil, sir, for his visionary guidance. Honorable Chancellor, Dr. Vijay Patil, sir, for his leadership and visionary support. Honorable Pro-Chancellor, Dr. Shivani Vijay Patil, madam, for her support. Vice Chancellor, Dr. Vandana Mishra Chaturvedi, madam, for her support and cooperation. And last but not the least, in this list, our dear Director, madam, Professor Dr. Karuna Akshay Malviya, for her constant encouragement and motivation for engaging in such knowledge sessions. Thank you, ma'am. We have to thank our organizing partners, Institute of Medicine and Science, their office bearers, and our very own Associate Professor, Dr. Chirag Balyan, for their efforts in making this event possible. Last but not the least, our sincere thanks to all attendees, the esteemed faculty and dear students of not just School of Law, but our collaborating schools such as School of Medicine, School of Public Health, School of Pharmacy, for attending this event patiently. And thank you to our organizing committee, all our technicians, and security, housekeeping, everyone. Thank you so much.
I request all to please come in the center for a group photo.
Karuna ma'am, can I speak for 2 minutes? सर 2 शब्द कह लूं? आप जब बोल रहे थे तो मैं अपने कपड़े देख रहा था, है नहीं है. And every time sir used to say, वाजपेयी जी सही बोल रहा हूं कि नहीं? ठीक है. In our initial days we were always taught, never sit with the judges. In fact, we communicate, we interact with judges only informally, only on the day they retire. बहुत दिनों बाद एक साथ बैठा, सर समझ में आ गई ये पुरानी बातें.
I request all to please gather at the center. I request all to please be seated for our next session. special lecturer. Presentation. Yes, sir. Yes, sir. Sure, sir. This one. Done there. Yeah. Yes, sir. moving forward to the special lecture by Advocate Mahendra Kumar Bajpai sir. Sir is India's leading authority on medical laws. He is a practicing counsel of the Supreme Court and honorary director of the Institute of Medicine and Law. His views on the subject are not only respectfully heard in India, but in many other countries too. His advice to doctors in difficult times is useful and unique. His practical tips on avoiding legal problems are highly valued by the medical fraternity. His extraordinary ability to explain the most complex legal dictums in a layman's language makes his speeches not only interesting but also of practical use. Known for his forceful arguments in courts, Advocate Bajpai sir is a reputed speaker commanding respect of both the legal fraternity and the medical community. Now we move to the centerpiece of our afternoon. I invite Advocate Mahendra Bajpai sir, a renowned expert in medical law, to deliver a special lecture. Sir, the floor is yours.
Thank you for those kind words. Friends, if the person ready to give the vote of thanks is here, we can finish off this event right now. First, I am a poor lawyer. There was a judge here, judge from the Constitutional Court, and he gave us all the solutions for which we are sitting here. Ethics, morality, transparency, whether it is lawyers, whether it is doctors. So we have solutions. Now, as far as law was concerned, we had the honorary director, Dr. Karuna ma'am. Both the major legal developments that have happened in 2025, she has already shared with you. क्या किया जाए, sir? So friends, this is the 18th annual MedLegal review. Very different from what we used to do in one sense. Our earlier reviews was done with hospitals, it was done with medical associations, and for the first time we are doing it in a law college, with a law college, with their collaboration. This review was meant for healthcare providers, for doctors, hospitals, hospital administrators, especially the leadership, so that they get an overview of what is happening in this space and the way forward. Very broadly, in the next 45 minutes, I'll try to make it shorter. I know we are already running behind schedule. We'll try to conduct this review broadly into three parts. The newer issues that have cropped up in this MedLegal space. The second part would be purely legal issues. Something that has come from the court, some issues in court. And the third part would be the older issues which have again come in focus. So in a nutshell, in 2025, doctors and hospitals were punished for procedural lapses, for administrative failures the amount of compensation, as it has been happening for the last so many years, is increasing. Even this year it is increasing. We saw that rise happening. But this year what was very important is that even criminal proceedings against doctors and hospital administrators seems to be on the rise. The era of digital scrutiny has started. Digital evidence is going before the courts in medical negligence cases. Clinical errors are fewer. Purely clinical issues, wrong drug, failure to diagnose, delayed diagnosis. These issues as compared to the earlier years are fewer. But something that could be called as paperwork errors, procedural lapses, they are increasing. 65,000 cases against doctors and hospitals. 2025, the Department of Consumer Affairs, they have brought out a portal, e-Jagruti. This is the government data. How many doctors are there in India? 10 lakh, 15 lakh, 20 lakhs? 65,000 of them are there in consumer courts. Leave aside the criminal cases. Legal protection has been given to nurses in criminal medical negligence cases in Kerala. And a recommendation has come again from the Kerala High Court that whenever an expert opinion is sought, the doctor must be called before that expert committee. The opinion, the reason, the rationale why the doctor did something should be taken personally from that doctor. Way ahead. What do we see in 2026? The DPA rules have been notified. They will come into effect. And it's going to have a big impact on healthcare. Mobile footage, not oral testimony, is going to become the primary evidence in consumer courts. The way the consumer courts are relying on this evidence is questionable. Not following the Evidence Act. But nevertheless, video recordings, audio recordings, photographs, they are going to reach the court and they are going to influence the decisions way going forward. It is not only more cases that are going to happen. The cases that reach the court will be different. And that we saw in 2025. In fact, right from 2023. The nature of cases, the nature of allegations, the nature of even defense is changing. What are we going to expect? We are going to expect an increase in video evidence. Digital records will be scrutinized. Date, time on your ECG, on your CT scans. Consumer court claims are going to rise. Compensation awarded obviously is going to rise. Criminal complaints are going to rise. We can see that. Number of cases are coming before high courts for quashing. Administrators' liability. At least 5 years back, hospital administrators were never held liable. That is changing. And in fact, during the course of the review, I will take you through some very important judgments where not only civil liability but even criminal liability has been cast on hospital administrators, on the directors of hospitals. And insurance frauds and financial frauds are happening. They'll increase in the days and years to come. Friends, this is, in fact, the title given, eye opener, is bad, not in good taste. Something a cause of concern for everyone who is concerned about healthcare in this country. Around 65,000 cases against doctors. After services such as insurance, banking, housing, electricity, finance, medicine comes at number 6. Is this situation so bad? Or are there any systemic flaws? Policymakers really need to think on this aspect very seriously. New issues that we saw in 2025. It would not be wrong to say that 2025 was the year of nurses. Kerala High Court extended the protection given to doctors in Jacob Matthews case to all the nurses who practice in Kerala. What that means is, if the police wants to proceed against a nurse in Kerala, they will first have to go and take a medical opinion. Only after that they will be able to proceed. A laudatory judgment, something that we were waiting. The Supreme Court should take cognizance, or the government should take cognizance and bring this protection at an all India level. The second most important things, there were judgments where the documentation done by the nurses has saved the doctors, has saved the hospitals. The first case is that Matthew versus State of Kerala is where the Honorable High Court has given that judgment that nurses prosecution of nurses should follow Jacob Matthews case. The second one, Chief Medical Officer, Nehru Shatabdi Center. In this case, the patient was managed conservatively for a snake bite. The dispute was that when the patient had come, ultimately the patient lost her finger. The dispute was that who had tied the thread around the patient's finger. The hospital was saying when she came in, already the thread was there, and the patients were saying, no, the hospital tied it. It was the nurses' notings in the medical records which saved the hospital. Similarly, in the next case, head of the Department Institute of Human Behavior, a cyanosis had developed in the left hand of the patient. Amputation happened of the fingers. Now again there was some dispute regarding who has administered the injection. And fortunately again the nurse's notes at the time of admission, where she had recorded that there is some pricking there, it saved the hospital. Moving to the next topic, technological evidences. Friends, open secret today, every piece of paper is photographed by patients and their attendants. And every interaction is video recorded. Courts are taking cognizance, and I have already shared with you, not the legally correct way, the way evidence should be produced, but ultimately these are consumer courts. They have to dispose of cases in a summary manner. And even if they don't take cognizance, the fact that a video is produced of a ailing 91-year-old patient, it is enough to get the sympathies of the court, and this is what is happening. Unfortunately, the current guidelines have failed to keep pace with the technological evidences. CCTV footage. how many days or months should a hospital preserve it? There is no guideline. And in fact, one of the hospitals, Apollo Hospital was there. They said 45 days we preserve the CCTV footage. After that we dispose of. Fair enough. There was a very sympathetic court which did not hold them negligent. There would be another court which would say, why 45 days? You preserve your medical records for 2 years. There is no guideline. And we have been lagging behind even in a sector as important as healthcare. The first case that Akhilesh Kumar, a false COVID report resulted in a 91-year-old patient being kept isolated during hospitalization for a few hours. The court's sympathies are evident. Let us read what the court says. The son, he showed a video recording of the patient. And the court says the sensory of deprivation, isolation and underlying medical conditions certainly increased her risk of delirium after seeing that mobile. Acceptable, not acceptable in law, it comes later on. This video has appealed to the conscience of the court, and this is what the court has done. The hospital is held negligent. Next one, CT of the patient is taken. Before taking CT, contrast medium is given to the patient and the patient collapses. He dies there. Now the patient's advocates points out, look, there is a difference between the time recorded in the CT of this patient, digitally that time has come, and the time recorded in other medical records. Again, here the hospital was fortunate. The court said there may be some differences here and there. There are so many reported cases where the difference in time, it has been taken as an instance of negligence. So one take-home message, especially for hospitals and even for clinicians. The time of the watch of your nurse, the clock which is up there, all the equipments and gadgets that you have, they should be synchronized. Another case, Mission Hospital and another. Patient died from fresh injuries. He fell down from the stretcher. The relatives were happy making a video. There was a delay in attending to that patient. Video was shown to the court. And the court has written in its judgment, yes, we have seen that video. And we understand the hospital was negligent. The problem here would be in this AI generation. Generating such videos is going to become very easy. There is a way in which you produce evidence in court. Unfortunately, the consumer courts are not taking cognizance of something like this. You produce it, we will see it, we will write it in the judgment. Criminal liability. Administrators and even when doctors communicate with their nurses, with their staff, with other doctors on telephone, and both are cause of concerns. I have already shared with you that cases against doctors are rising because we see every other day in some high court, quashing proceedings are there. Let us wait for the next report of the National Crime Records Bureau. We had the last one in 2022. Comes after 5 years. 22 के बाद नहीं आएगी. Dr. Chirag says आ जाएगी. Let's wait. But the cases are rising. The biggest problem here happens to be that the police is insensitive. By arresting a doctor, by prosecuting a director, by prosecuting a hospital administrator, you are doing disservice. It is not that they should not be prosecuted. The first one, this case of Vinod Shaili and another. In this case, no doctor was sued, only the hospital administrators. And that too, the patient's relatives had filed an FIR. FIR was registered. What was the wrong? The patient had undergone a routine uterine fibroid surgery, developed severe complications and died after being transferred to another hospital. Purely medical case. But again, it is not the doctor but the hospital administrators and staff who are sued. And the Rajasthan High Court had to quash. Again, the principles that are involved. In such cases, the High Court has reiterated. The next case, Dr. Mohan versus the state of Rajasthan. Directors of the hospitals are charged with the forgery of investigation reports. High Court again quashes the criminal proceedings. And please see what the High Court is saying. See the observations. In medico-legal matters where the stake often involve not just reputations but also public trust in healthcare systems, courts must exercise extreme caution to avoid being influenced by mere bald or motivated allegations in criminal cases involving doctors and hospitals. This is what the Rajasthan High Court is saying. Yet another case. Doctor gives telephonic instructions to the staff nurse to administer an injection and the patient dies. Charges under section 304 part 1. Not 304A is levied against the doctor. The reason? 304 part 1 is non-bailable. The relatives want the doctor in the jail. There is no intention to kill. There is no intention to harm the patient. 304(1) cannot apply. And that is what the Supreme Court says. The doctor has to run from the Sessions Court to High Court to Supreme Court. And there these proceedings get quashed. The third case. A gastroenterologist, he is charged with causing death by criminal negligence. Why? Gave telephonic instructions at 4 o'clock to the nurse. He was not the attending doctor. The attending doctor was out on a vacation. FIR filed. Expert panel comprising of 3 medical officers and the district government pleader, this is Kerala, they have a written procedure. They opine there is no negligence. The police goes to another committee. In this committee, there is head of department of gastroenterology and nephrology, government doctors in the local government medical college. They again say there is no medical negligence. Now they move the state apex level apex body, which is there in Kerala, under their local rules. And they say, yes, this gastroenterologist ought to have physically visited the patient. Patient was not of this poor doctor. It was someone else's patient. He attends a call at 4 a.m. And after that, FIR is registered. The moment Apex Committee gives its report, the police files an FIR and the doctor has to now get it quashed. It is quashed ultimately, but by the High Court. And please see what the High Court is observing. By no stretch of imagination, it would be said that the above course adopted by the petitioner, that is the gastro, would amount to an act of criminal negligence. Police certainly needs to be sensitized. This new trend, and the doctor sitting here would really not be happy with what is going around. We had observed this trend in the last year, but this year it has firmed up. If your patient happens to be a doctor, or a very close relative of your patient happens to be a doctor's son, spouse, the probability of these people going to the court is n times higher than a normal patient. And then all sorts of allegations are made. Professional rivalry, personal enmity. The relative of this patient is also a doctor. He fought against me in the IMA election. That is why this case has been filed. All sort of allegations. On the other side, courts are more puzzled. When the patient is a doctor, on one hand, the court holds that doctor patients are patients and must be treated as such. On the other hand, the court presumes that, oh look, he is a doctor. Once you have given him a proper medical advice, he will follow it. He is not an ordinary patient. First case, Dr. Manju Dadu, patient was a 62-year-old doctor. Developed a brain hemorrhage post-angioplasty and subsequently slipped into a coma. Written consent was given. Daughter was also a doctor. For angioplasty, had given a written consent. Even after that, the court holds the doctor and the hospital negligent. There were other reasons, but the court did draw adverse inference against the hospital and doctors. Why? You did not counsel this doctor properly. The defense of the doctor, of the cardiologist, was he is a doctor, well qualified doctor. Doctor in modern medicine, even the daughter who was there with this doctor is a doctor. But the court says no. And I am quoting the court. The cardiologist cannot shirk their responsibility by saying that the patient and his daughter were doctors and that they had given their informed consent, knowing well the risks and benefits. Let us go to the other case, Dr. Rajni Saigal's case. In this, the court refused to believe the defense put forth by the ophthalmologist that the patient, a doctor, had failed to comply with follow-up instructions, and that resulted in complications. This is what the court is saying. There is no reason to believe that the complainant, who is an educated person and a homeopathy doctor herself, under deep distress and pain, will not follow the advice. Next case, the Dr. Sharad Lakhotia's case. Patient is an obstetrician. She undergoes IOL implantation and claims that the ophthalmologist was negligent, and this led to permanent loss of her vision. Now she continues this tirade against this ophthalmologist for years on social media, newspaper. So it's not only the patients who are going to social media. Even doctors against doctors, social media, newspaper, everything is used. Later in court, she admits there is no loss of vision. And the ophthalmologist points out in court, he files an affidavit. And what he says is that this complaint is driven by a personal conflict involving patient's brother-in-law, who was his political rival in IMA election. That is why this lady has filed this complaint against him. The next one, Amardeep Hospital. Patient undergoes surgery for a thigh fracture, a gauze piece is removed, and the defense taken by the hospital is, look, it is because of the professional rivalry between doctors, so obviously the court rejects it. But these types of allegations, these types of defenses are being made in court. It would not be wrong to say that the doctor in court, a doctor as patient, the chances of this doctor reaching the court is far, far higher than a non-doctor. Next issue, the POXO trap. Again, this year we saw, around 3 years back we had seen doctors being prosecuted under POXO. Policemen, they expect doctors to verify the age correctly. And if the patient is below 18, report it to the police. Even earlier, the high courts have said in so many words, doctors are not required to do a roving inquiry. If the patient has given an age, you have to record it and you have to continue with the treatment, especially if it is borderline, 16, 17, 18. But the policemen, they are continuing with registering cases. Ultimately, the doctor has to reach the higher court for quashing of the criminal proceedings. Again, a very painful job. Especially the first case, that Jembaga Lakshmi case, 70-year-old gynecologist. Entire life she has spent with patients. 16, 17-year patient comes. Skip this. In fact, if you see this Ambujakshi case, the court has said, and I'm quoting it, as a natural phenomena when a patient meets a doctor, Kerala High Court is saying, the doctor would act upon the age disclosed by her, and no roving inquiry in this regard is mandated by law. And then a word of caution for the policemen also. While implicating doctors in criminal cases with the aid of section 19 of POXO, the investigating officer must apply the mind from the materials collected and from an unbiased opinion to see prima facie that there is deliberate intention or omission to report the crime. Unless this said deliberate intention is not divulged from the records, unwarranted implication of doctors in crime shall be avoided. Please avoid it. Yet things are happening. Confidentiality issues, they are gaining traction. With DPDP Act coming into force, it will multiply 10 times. So extra caution is required. See, again, let us understand Indian society. Healthcare decisions are made by the family. And that is very obvious. And when a near relative comes to ask for reports, saying no is a tough job. And you give that report, you have breached the confidentiality. First case, this Sharad Lakhotia case. Now, this is a place where hospitals have to be really cautious. If another hospital wants the medical records of a patient, then you have to be very cautious. You have to take express consent from the patient. Now, here the other hospital was taken to the court by the patient, and the first hospital came to the second hospital. They shared the medical records. Fortunately, nothing happened, or the court did not take this issue seriously. Otherwise, it was a breach of confidentiality. The next two cases is where the husbands, they had gone for treatment with the wives, obviously to the doctors, and later they went alone, got some reports from the doctors and used it in court for divorce proceedings. You have to be really cautious when you are giving some reports, especially sensitive ones. Legal issues from courts, legal issues and issues from courts. Expert opinion, Karuna ma'am has already shared that the Kerala High Court has now said that if an expert opinion is required, the court refers a matter for expert opinion. In that case, the expert must call the doctor concerned. If not, at least a written clarification must be taken. It was required. Ultimately, at that point in time, what happened? Everything can't be recorded. Experts are doctors. They will be able to appreciate what has happened with the patient. This was needed. Guidelines have been endorsed. Let us see when they are notified or when they are taken cognizance by the lawmaking authorities and they become the law of the land. But something like this was really required. One more thing. For the first time in India, an expert panel visited a hospital. In reported cases, for the first time, something good. Bolam's law, something that defines, describes medical negligence, something that lays down the contours of the standard of practice, reasonable care, accepted medical practice. And amongst academicians, legal academicians, a debate is on whether in India we follow Bolam's law or whether precedence is given to Bolitho's law. The Supreme Court has laid to rest all doubts. In this case of Neeraj Sood and another versus Jaswinder Singh, the Supreme Court has said, no, we follow Bolam's law. Simple lack of care, an error of judgment or an accident is not negligence. A better alternative course of treatment was available. You did not take it, you are not negligent. That more skilled doctors were there who could have administered better treatment, fine. This doctor had not adopted any unacceptable medical practice, not negligence. And ultimately, if you were properly qualified, you had the requisite skills and you have used it in proper way, you are not negligent. But yes, there is one issue here. and the issue is of certain practices which may not be best practice. It may even be an unreasonable practice, but everyone practices that way. And there are times when the court has held that even such unreasonable practice would be acceptable. Professionals, bodies and regulators need to take cognizance of such issues and act. One of the best cases on Bolam's law. After a long time I have come across it. Very interesting case. The patient was suffering from hallux valgus and the orthopedic surgeon performed PMOD STR on her left foot. The patient claimed that her deformity worsened due to the choice of a complex surgery. Instead, a simple K-wire method, which was performed by another surgeon later, would have solved her problem. This is what she is saying in court. The orthopedic surgeon in defense stated that the surgery that he performed, the course of action that he chose, was well established, commonly used procedure, and he brought a standard textbook in court. And for this indication, there were 130 procedures written down. Not 1, not 3, not 5, 130 procedures. And he said, amongst these 130, I had to choose one, and this one I have chosen. The court held he was not negligent. So, medicine does has its own share of problems. I'll skip this court's view. COVID cases are reaching courts. Views are balanced. The court has held that the patient's patients been wrongly declared COVID positive, unnecessarily quarantined. It is negligence, advance you have taken for a surgery and then under the garb of the COVID wave you don't perform it and you don't return the money. Even that is unfair practice. But if an old surgeon, he is not coming to the hospital and that is why he was unable to physically examine the patient, the court says no, this is not negligence. And hospitals' failure to quarantine its own nurses and doctors not held as negligence. So some indications, probably whenever there is another pandemic here or somewhere else, for the legal fraternity will get some guidance from these cases. Doctor-hospital apportionment of liabilities, this is one issue, legally speaking, which till date remains unresolved. Courts in India are giving different opinions. There is a doctor, he has a patient, he wants to perform surgery, the doctor chooses a hospital. This doctor decides on the course of treatment. In that hospital, he is the attending doctor, the treating doctor. The other hospital merely provides infrastructure and nurses and paramedics. Now who is liable? Conflicting judgments. Because the patient was in your hospital, although that doctor was wrong, all the wrongs that we have come across, all the negligent acts, were clinical in nature, for which that doctor has to be blamed. But still, courts are applying the doctrine of vicarious liability to hold hospitals negligent. Clarity was required, not coming. The formula for compensation, this is something that even the academicians amongst the legal fraternity, they are really disturbed. At times the court applies the multiplier method, and this time in this DC Malviya case, The Supreme Court has said, and let me quote it, the value of human life cannot be assessed in monetary terms. Whatever is awarded is a matter of solace, no formula. And the deceased patient's husband had very specifically pleaded before the court, please apply the multiplier formula. Court says no. There are cases where the multiplier formula has been applied. Clarity is needed on this issue. We have the Jacob Matthews case, where it's very clearly said by the Supreme Court that no criminal action against doctor by police until you get a medical opinion. No legal proceedings. What does that mean? Can the police file an FIR, especially in the light of Lalita Kumari's case? Or can they not? Here is a case from Madhya Pradesh, where the court has held that until and unless you get a medical opinion from another doctor, the police need not file an FIR. But there are judgments on the other side which say no. For some time the police can stop, but after that they have to file an FIR, maybe a week or 2 weeks, not till the time the medical opinion comes. So these are the issues. Patients' misdemeanors. By violence, forcefully, doctor is asked to sign somewhere, and then that piece of paper is used in court. Courts want the doctor to go and file a police complaint. And then they believe that yes, whatever you have written and given, that was under duress, that was under threat. Then that Makaradhwaj case, Nayanthara case. In the discharge card at one corner in some different ink, O positive is written. And that is produced before the court. And the court observes that we think there was no reason for the doctors to write O positive here in the discharge card. You are the patient, you have the original discharge card with you, this is what you have written. State of Haryana, Dr. Makaradhwaj Prasad versus the state of Jharkhand. See the new laws that we are seeing. The deceased patient's son files criminal case against doctor, accusing the doctor of medical negligence and of an offense under SC/ST Act. This doctor, he made some caste-based abuse against me. And this doctor had to go to the High Court, and the Jharkhand High Court had to say both the cases were filed maliciously. In another case from Haryana, patient undergoes a vasectomy, wife becomes pregnant. He says that after this procedure, wife has become pregnant. Now this is a social stigma for me and for my wife. And my wife's character is being questioned. This is her Sita's Agni Pariksha. Fortunately, the court is not moved by these emotional appeals. And the last one, Ramesh Kumar Srivastav. Patient alleges she suffered from cancer due to negligent surgery performed by doctor. Enquiry conducted by Chief Medical Officer, no negligence. Now the patient sits on a dharna demanding compensation for defective surgery. Nothing happens. Now she goes and files an FIR stating that the doctor and his lawyer brother hit her with the motorcycle when she was sitting on the dharna. Allahabad High Court quashed the proceedings, and the observations are worth mentioning. The background of the circumstances indicate that the allegations leveled in the first information report seem to be with a motive to wreaking vengeance and malafide. All this is happening, friends. And then we have the Gujarat angioplasty case, where angioplasties are done just to take money under the PMJY Act. Fortunately, the court did not give bail to that cardiologist. Ayush doctors, again, a big issue. Every hospital in this country is employing Ayush doctors, all size of hospitals. What they can do, what they cannot do. Why can't we specify? And then in courts, there are judgments on this side, there are judgments on that side. In fact, in a very interesting case, this Mata Chanan Devi case, the hospital where a BAMS doctor is employed, that is taking this defense. The Vaid, a BMS doctor is employed, and the hospital is saying that the Vaid may not be relevant to comment on treatment received. He does have the requisite skills to record. I'm sorry, this is what the court has said. The Vaid may not be relevant to comment on treatment received, but he does have the requisite skill to record temperature of a patient before him. The case was, the hospital had employed a BMS, and the hospital was pleading in court that the temperature recorded by this BMS should not be taken seriously. And the allegation by the patient was that the patient was discharged prematurely, he was running a fever, that was recorded in the discharge card. So friends, as far as Ayush doctors are concerned, clarity will help everyone. Unfortunately, it is not coming. Different states have brought out different circulars. This is permitted, this is not permitted, this much is permitted, this much is not permitted. Government hospitals, doctors, schemes, big cause of concern, friends. I'll skip this. Credentialing and privileging still remains a big cause of concern, especially privileging. Whether an MD doctor is competent to man an ICU or not, there is a dispute on this. Whether an orthopedician is a rheumatologist or not, and can an orthopedic surgeon prescribe rheumatoid drugs? And the mother of all cases, if you ask me, is this K. Rajgopalan versus Rega and another. A surgeon performs a surgery, the patient dies. This surgeon has given anesthesia. Criminal proceedings are initiated. Now this surgeon shows in the court, look, I was a government surgeon and I was transferred from this hospital to this hospital as an anesthetist. This is my transfer order. What will the court say? Criminal proceedings quashed. Caesarean, again a big cause of concern for obstetricians. I had asked the obstetrician to perform a caesarean, she did not perform. Negligence. The obstetrician wanted to earn more money, that is why did not try for labor, straight away caesarean was performed. And there are at least 2 reported cases where the patients have said, We had undergone cesarean for our first delivery. This was our second delivery. Why did the obstetrician attempt a normal delivery? A cesarean ought to have been done. And in both the places, expert opinion comes in saying, no, that is permissible. There's nothing wrong. Doctors dispensing drug, the Bombay High Court has again said. In fact, two things worth remembering. One, doctor can dispense drugs to his or her patients. Absolutely permitted. No licenses are required. And number two, the quantity that the doctor can store to dispense to his or her patient, any quantity. There is no legal bar. Friends, I have exceeded the time by around 15 minutes. I won't take you to the recap. Thank you. Thank you for listening patiently.
Thank you, sir, for the wonderful lecture and the mention of various case laws. Moving forward to one of the most anticipated segments of the day, our panel discussion. It is an honor to introduce our distinguished panel of experts who bring us a wealth of knowledge from the fields of medicine, public health, and law. Our first panelist is Dr. Suma Nair ma'am, Director of the School of Public Health at D.Y. Patil University. With over 30 years of experience as a community physician, researcher, and administrator, she previously held senior leadership roles at MAHE Manipal, including Head of Community Medicine and Director of Student Affairs. A recipient of prestigious international fellowships from the European Commission and the NIH, ma'am is a distinguished academician honored for her excellence in teaching and her global contributions to preventive medicine and public health. I request Professor Sonal Satelkar ma'am, our Professor of Practice, to kindly felicitate our panelist with a token of appreciation. Okay. It's an honor to introduce our next panelist, Dr. Swati Sonavne ma'am, Professor and Head of the Department of Forensic Medicine and Toxicology at D.Y. Patil University. An accomplished MD and researcher, Dr. Sonavne ma'am is a leading authority on DNA profiling and forensic investigation. Her work serves as a vital bridge between medical science and the pursuit of justice. Please join me in welcoming her. I request Sonal ma'am to kindly felicitate her. Our next panelist is Dr. Chirag Balyan sir, a founding faculty member of MNLU Mumbai and a former law clerk to the Chief Justice of India, an alumnus of Nalsar and Symbiosis, Dr. Balyan sir is a recognized authority in international arbitration and criminal law. As the founder of Mediation Bombay and a certified NLP life coach, he has spent over a decade bridging the gap between legal theory and professional practice. Please welcome Dr. Balyan sir. I request ma'am to felicitate him. It's a pleasure to introduce our next panelist, Dr. Shrikant Shetty sir, one of India's leading authorities on medical negligence. Uniquely qualified in both medicine and law, sir is the editor of medical law cases for doctors and manages the country's largest database on medical jurisprudence. Known for his practical, anecdote-driven insights, he is a speaker who truly bridges the gap between the clinic and the courtroom. I request Sonal ma'am to kindly felicitate him. Last but not the least, serving as our moderator today is Dr. Amit Kumar sir, Assistant Professor at MNLU Mumbai and a prestigious Max Planck Fellow. An alumnus of Delhi University and the Indian Law Institute, sir is a recognized expert in health law and human rights. With a background that spans government, corporate sectors, and international research in Munich, he is uniquely equipped to lead today's complex discussion. Please welcome Dr. Amit Kumar. I request the panelists to take their positions for this vital dialogue.
All right, a very good evening. So I welcome you all once again to this very interesting discussion that we're going to have. The context setting, in fact, has been also very apt because in the audience we have doctors, lawyers, would-be doctors and would-be lawyers, right? And we are discussing precisely that, the intersection of law and medicine and attendant issues that actually currently plague the intersection of medicine and law, right? So we have with us today a very eminent panel that has been introduced, right, who bring with them, in fact, expertise in medicine, clinical settings, legal and policy perspectives too, and we hope that we'll have a fruitful discussion, right? So I would like to then start the discussion by first addressing the question to Dr. Swati, madam. I would like to address, first of all, certain structural issues and the liabilities related to that, and we can continue to discuss that later on also. So what I would like to ask you, ma'am, is that, see, government hospital, if you look at the current scenario, government hospitals continue to attract disproportionate litigation and also public criticism. They're always in the public eye, right? So from your experience, when courts are asking for a lot more accountability, right? While the public hospitals face wide, spread overcrowding, overstaffing shortages, and infrastructure deficits, how do you think government hospitals, how fair is it for the government doctors to be judged on private hospital standards?
If we compare the government hospital and private hospital, there are two different scenarios. If we see the government setup that we have, there is a less number of medical colleges, and the patient burden is very much as compared to the faculty strength which is available in the government hospital. So the quality care which is provided to the patient, which is not, we can compare with the private practitioner or private hospitals which are providing. Because in private practitioner, private setup, there is a patient load is less. So we can give the good quality healthcare to the patient. So that is the difference between government and private setup. So litigations are more with the government because there is a lack of resources, lack of infrastructure, and again I'm telling there is a lack of expert doctors. That's why there is more litigation. And
but would you admit then that court should empathize with this scenario, because the scenario is drastic? The kind of load public hospitals have,
yes,
it can't be compared
and
to
public having more, the people who are belonging to the low social economical status, they have more faith in the government hospital. They don't have money to pay in the private setup, because if they are going to the private setup to investigate, they, for example, for CT scan, they have to charge 4,000 rupees. While they go to the government setup, they have to pay only 1,800 rupees. So there is no uniformity regarding the investigation anywhere all over the India. So regarding investigation, blood report, there is no uniformity of the charges.
I'd just like to interject with one statement here. The courts are quite lenient with government hospitals. I have looked, last 1 year of judgment, Tier 2, Tier 3 cities, court is very lenient with government hospitals.
What level courts are you talking about, sir? Higher courts?
I'm talking of all courts, because they are basically all district commission, state commission, they are lenient. The reason being lack of facilities. It's Tier 1 cities, they are somehow stringent because government hospitals also have as good facilities except for the overload of patients. Right. They have good facilities in Tier 1 cities. Tier 2, Tier 3 courts are, in fact, Northeast, Calcutta, you got so many judgments which the courts have said ki government doctors are not liable.
Maybe urban centers don't have staff shortages, but if you look at some institutions like AIIMS, the problem of overcrowding remains, right? And then they're not directly comparable to private and the public institutions. That's why what my observation would be.
As for the what is the new policy by the government in the last year, they introduced 8 new medical colleges, government setup. But if you see the scenario, there is a very lack of infrastructure and faculty also. So instead of increasing number of medical colleges, if we focus on strengthening the faculty in every medical colleges, then it will be utilized to provide the good care to the patient. Everyone will be eligible to get that service with available resources.
So on that note, related question to you only. Do you think, there's a debate always on prohibiting private practice by government doctors, right? Do you think when we are facing, this country is facing such serious gaps, the doctor-patient ratio is very, very poor. Do you think allowing public doctors, government doctors, to also practice in a private capacity, would that strengthen or would that mitigate the scenario a little bit?
Actually, if we see regarding the government doctors, whether allowed to do the private practice, there is what we call NPA, non-practice allowance. If they are doing practice after their duty hours in the government hospital, they will not get NPA allowance, non-practice allowance nahi milta hai. But what happened because of this prohibition to practice, what is concern behind it, they should be available to the all people in the public sector 24/7, whatever time duty is there, availability should be there, and they should do their work with the dedication. That is a concern behind the prohibiting doctors, because what happens, it's normal tendency. If I get a chance to transfer the patient from government to the private, I will refer the patient. So to prevent this type of errors in future, we should have some control. If someone is referring the patient who is admitted or who is encoded in the OPD system or IPD system, if that patient is referred to the particular doctor, so we should keep the record to find out the lacuna, why this patient is referred to such thing. That can implement, and we can allow them to practice beyond duty hours. They should provide some time-bound service in the government setups. We should give some goals, how many surgeries they have to do per month, and I think we should allow them. Because there is a salary gap if we compare in the government setup and private setup. Private, if the doctor is doing surgery in his own setup, the salary is very high. Whatever income is there is very high. And if we compare the salary which gain from government setup, it's less. So if the salary is increased, everyone will be put every efforts to improve the healthcare system.
So you agree that we can, with some checks and balances, allow private public doctors to also practice in a private capacity.
That's why I think it should be allowed.
Fine. So after these structural issues and resource constraint and capacity issues, I would now like to address the third question to Professor Balyan, right? And as also the speaker, Mr. Vajpayee has very aptly pointed out in his elaborate address, right, that there are the cases against doctors, cases of medical negligence against doctors are rising and rising exponentially, right? The data he quoted, 65,000 as per consumer e-Jagriti portal, right? So do they signify or are they, indicative of any genuine patient empowerment, or the rise of such litigation, is kind of a perverse scenario that's prevailing now, driven by intermediaries, incentives, or ulterior motives?
Thank you for this question. In fact, Advocate Bajpayee in his presentation mentioned about 65,000 such cases, and it would seem like a situation is alarming. But I do not think that the situation is alarming as it might appear like. That would only constitute, he mentioned we have around 20 lakh doctors in India. That would amount to around 3% of cases against the doctor, only 3% of doctors, that too on an year basis, which is far, far low as compared to developed countries, wherein percentage would go to 8%, 7%. It hovers around 7 to 10%. And in fact, in United States, by the time a doctor retires, 40% of the doctor might have had a case against them. So when we think about numbers, we must also think that what is our doctor to patient ratio and what is our population to patient ratio. We are a very big country, 1.4, 1.5 billion population. So the first point, as I see, it may not really be alarming. Second point, there are many dissatisfied patients. Now, what is the existing remedy they have? Now, this is not a problem necessarily of ambulance chasers, as we see in United States, wherein there are advocates who are running after the clients and saying, okay, let's sue this hospital. I'm not saying this does not exist in India, but this is not a pattern in India. This is a thing of the West. What we see in India, irrespective of the wrong, the first thing, whenever a wrong happens to us, whenever a harm happens to us, by default, the only thing which is accessible to us is police station. The only thing now with e-Jagriti platform which is accessible to us is a consumer court. These are the most accessible thing to the public. Now, where do they go? We do not have proper counseling places. We do not have alternative dispute resolution places, a place wherein this dispute could be mediated. We may not have ombudsman at place in the hospital. So there are lot of things which could have been at place wherein this patient might not have gone. In the absence of proper advice, in absence of proper direction, they tend to go. So yes, there is some kind of patient empowerment. We are becoming a right conscious society, but that's not simply a trend in the MedLegal sector, as Mr. Ravinder would say. It is a trend, generally speaking, across all sectors. Aren't there cases in other fields? Aren't there cases against academics? Aren't there cases against judges? Every person is under scrutiny, and that is also somewhat attributable to, as Advocate Bajpayee mentioned, because of technology, because of access generally to information. So there are multiple reasons why we have these number of cases, and they are not necessarily bad. As we say in conflict studies, conflicts are not necessarily bad. It is because of these conflicts, the law, the practice is evolving. Now, there were so many doctors some time back which would not do the documentation proper, which would not do the diagnosis proper, and they would, a patient has come and after 1 minute, okay, this is your prescription. Okay, thank you so much. Because of these conflicts, a learning is happening. So there are many ways of learning, and this is also a way these cases, when they are filed, doctors and patients as a community, they are learning and they are moving toward a much more sophisticated practice. So these are some of my views on it. Thank you.
I'm sure our friends from the medical fraternity will have a different take on this.
I'd like to put on my doctor's hat and say this. We require a quick redressal of a complaint. Here I don't know how many noticed the slides which was shown by Advocate Bajpai, the DC Malviya case. The litigant is dead, the doctor is also dead. We are looking at a process of 15 years. That is not, USA, the redressal is 2 years. So that is the first problem. And how educated are patients? I say something, they take it in another way. They have opinions by family members. So this is, quick redressal is the answer. We don't have it. District Commission, 4-5 years. State Commission, 6-7 years. The National Commission, another 8 years. Totally 14-15 years. Even Rama did not have so much of exile as much as a doctor has. First. Secondly, a doctor who can handle patient, he can life and death decision. He knows, I have to do this, I have to do that. Moment he gets a court notice, he panics. Why should he panic? Because we don't know the law. Documentation, I accept, there are some mistakes. But priority is patient, then what? Nobody wants his patient to die. Just thinking like a doctor, so my apologies.
Absolutely. I would also tend to agree. In fact, I have to be neutral here. But of course, see, life cycle of a medical legal case, any case for that matter, is excruciatingly long, right? And that itself is suffering. And that brings me to the next question, and a light question to you only. Is it useful, what you were arguing, in a resource-constrained setting, does such adversarial consumer litigation actually help, right? Would it help? Of course, to you, addressing to you, of course. I would understand, would only encourage defensive medicine practices, long-term cost escalation and all of that, right? So my fundamental question also would be here that should healthcare still continue to remain under the Consumer Protection Act that also has been pointed out by Dr. Bajpai?
See, my message to the doctors would be, do not be afraid of legal notices. Again, Advocate Bajpai's presentation made it look alarming, and he used the words, apologies sir, prosecution and charges in a very casual sense. A doctor has been prosecuted. There is no prosecution unless the charges are framed. FIRs are getting quashed. FIR can be filed, it's a very normal thing. See, we need to remove the stigma around FIR. FIR is just a first information report. Something bad has happened, you go to the police, it is filed by the police after preliminary inquiry, not preliminary inquiry, Lalita Kumari followed, no different thing. You go to the court, you get it quashed. Again, charges have been filed by the police. Police do not file charges. Court frame the charges. I want to understand from the statistics which have been examined from 25, in how many of these cases actual charges were filed by the court, were framed by the court. If that is happening, then the situation is alarming. See, these are the routine grievances. We cannot tell patients, do not go to the court. Every person, every citizen has an access to justice. They think some wrong has happened, they do have a right to go there. So, is adversarial good? I'm never a believer of adversarial. I'm just saying, if we have some peaceful mechanisms like mediation, like ombudsman, that's always a better scenario. But if the patient is pursuing a remedy that is not necessarily alarming, even if it is malafide, it is malafide, understood, but there is always a recourse in the law. Now, and it's not, see, for the doctors, it is happening now since few decades, and that's why it sounds like, tell me any public office where a person is discharging official duties, cases are not being filed. Tell me any politician which is discharging, and not just for the corruption and all, where the cases are not being filed. It is part, and if you talk to a criminal lawyer, he would say it's very ordinary. Lawyers, again, my apology to advocates here, would make a big issue out of it, to extract more money, As our justice said, it's a bailable matter, file for anticipatory bail. It's a bailable matter. Police is not going to come to your home. It's going to send you a notice, just reply. We need to be better aware of our legal rights. Yes, we need to sensitize police. At the same time, we need to educate patients as well as doctors. We need to educate everybody rather than getting afraid. This fear is creating mistrust. As Dr. Amit was mentioning, now doctors are doing over-diagnosis. Earlier, what would have been just a clinical diagnosis, now at the first stage, go to the radiologist, go to sonography, which would have been happening at the later point of time. So I think a balanced approach is required. While I understand there are reasons for people who have suffered, but I think getting into a panic mode is also not an answer. My view could be, in an audience like this, could be extreme, but yeah, this is how I view as a criminal law teacher. Thank you.
Shall I put in my word as another doctor again? First and the foremost, going to court for a doctor in a consumer court, sitting there from 11 o'clock to 5 o'clock is a very difficult task. And you are not even sure your number is going to come.
So process is punishment. Process itself becomes punishment.
Says, the process is, the due process of law is a punishment itself. That's the first thing. After the 2019 amendment, the patient can file the case at his place of residence. A patient from Calcutta has come to Bombay and I have treated him and he dies. He can file it in Calcutta. What about me? I have to be attending that. Those things, those practical things are not seen by the real people here. I mean, somebody mentioned Parmanand Qatar has given you the right. It has given me a right as a witness. If I am the accused there, I have to sit the whole day there and my number may not even come.
Right. So I can take perhaps one comment from the audience. Mr. Mangal was raising his hand. Briefly, perhaps.
To respond to you, Chirag, very quickly, I am borrowing this from Advocate Mr. Bajpai. As a patient, you want a spotlessly clean doctor with a very good reputation. A lawyer, you need a very crooked lawyer. You don't look for a straight lawyer. That is the difference. So any doctor getting a notice has to be really worried because it is his reputation that is at stake and his entire practice which is at stake. It is not the question of whether he wins or loses or what happens in court. That's it.
If I may be permitted to just make a little bit of a humorous content. Now, completely speaking as a lay person, I'm a journalist here. Are doctors and lawyers the only people allowed to actually practice their profession? Are other professions, their profession is called, as a journalist, I'm not practicing journalism. I'm writing an article, okay? I'm perfecting my craft. But lawyers set up a practice, so they are essentially practicing on all of us. Doctors are also setting up their practice. They are essentially practicing on all of us. Now that's a very humorous take. It's a very humorous take and it's a play on language. But something struck me that when Advocate Bajpai also said that, it's error of judgment is allowed. So that was a learning for me today. And it's a very interesting discussion. I will hopefully be given 5 minutes to give my point of view, but I just thought I'll interject that here. Thank you so much.
I'll just take a brief comment from the audience there, but we'll open the floor for audience later on. You can make a comment perhaps.
Mr. Balian mentioned something about over-diagnosis. It is not over-diagnosis anymore. It is defensive medicine. What are we looking at? Exactly. Previously, the doctors used to be treated with respect and trust. Today, court has defined it as a contract. He is a customer, you are a service provider. So let's be very clear. If the textbook tells me that I have to do 10 tests, I better do all the 10 tests. It does not make sense half the time. Because then I go by I know this is wrong. But then the book says it. Contract has to be fulfilled. And if the contract has to be fulfilled, then the rules have to be followed.
Yes, sir. Go ahead and briefly interject, perhaps, very brief. If somebody can pass on the mic for a minute or so.
When any medical practitioner receives any complaint, even a single police constable visits his clinic, this news is spread in all community, and in next few months or years, everybody, oh, case ka kya ho gaya? I am a medical doctor as well as a lawyer also in the field of medical legal field since last 40 years. I have faced all the sides. What doctors suffers and who reaches to the court of law, their pains, I can't explain in few sentences.
All right.
Thank you.
Thank you.
Being a short time.
Yes, yes. So I think it's a matter of perspective. Different perspectives are emerging, and it also triggers a lot of emotive issues over there, right? So, but we will now move on from doctors to nurses, and I will have a question to Dr. Nair, right? When we talk about medical negligence and all, doctors or in medical service delivery, doctors are in focus always. What about nurses, right? What Mr. Bajpayee has also pointed out, the recent Kerala High Court judgment has advocated granting similar protections, right? So, do you think they should get similar protection because they're also frontline workers, similar to Jacob Matthews' case, right? Should they be getting similar protections as compared to doctors because they're also doing equally sensitive work?
Yeah, thank you. So absolutely, because I think that was a landmark decision. As you all know, doctors are there, but it's a continuum of care. When you look at it, it's a nurse who's always there. They're always there by your side. In fact, they take a lot more, brunt of the problems. So essentially, you want them to practice in such a way that there is no fear. They also can give their best, and patient care becomes ultimate. So clearly, this legal protection is definitely going to improve that. So they can, instead of, again, just like doctors, they would also do defensive care if they are if they are not given this protection. So this, I believe, is going to really make a change. And clearly, it has to be across. It's not just one state which is, has agreed to it. But I think it should have a better repercussion because it's important for doctors and nurses. See, this kind of a distinction happens. See, each one is very important. It's a teamwork. It's not like only a doctor gives care. A nurse is equally important. So is all the other people who form a part of the team. So clearly, this kind of protection really goes a long way in ensuring better patient care. But of course, it has to come with regulations, protocols, accountability, probably even institutional responsibilities. If all of this go together, I'm sure this is going to make a huge difference.
On this very note, another question to Dr. Swati, and that is about the Ayush doctors, another set of practitioners who are not focused in our policy discourses, right? So what about Ayush doctors and their liability, right? There's a lack and there's a fragmentation also, as Professor Bajpayee was talking about, in terms of law and policy regarding Ayush doctors, right? Do you think this kind of a policy vacuum exposes, the Ayush practitioners to disproportionate risks? Because there's nothing, and there are fragmented court cases and court opinions also, right? What would be your take on that?
Basically, if we see the RMP, the term was RMP, registered medical practitioner. It is as per the law. It is as per the BNS 2023. It is considered as the whoever having the degree and whose name is registered in the National Medical Commission. He is qualified as a registered medical practitioner. And for Ayush doctors, whatever they are having degree BMS, Unani and Sindaki, तो उसमें क्या रहता है, if they are like bridge course जैसे last year में promote किया था, if they do the bridge course of 6 months in community health center, which is more promoted by Indira Gandhi University, Open University, if they are doing that course and they are can do the practice which is provided by the allopathic doctor, then it will certainly affect the quality of the healthcare. Okay, and randomly then MBBS people will also come and they will say, I will do 6-month orthopedician and I will be the ortho doctor. So it affecting the healthcare system. Okay, so there are different policies are coming and there again they are overlapping with the time after some opposition. So we need to streamline what will be their role and what will be their perspective in the future, in how way they will help in the society to improve the healthcare. And we don't have guarantee that Ayush people after doing that course also will go to the rural areas to provide the healthcare. We don't know what will happen. So if we are concerned about the doctor-patient relationship, we should give some other role to them to provide care to the society. Thank you.
Yeah, I just want to take from there. See, each specialization, each speciality have their own strength. So as an Ayush practitioner, you may be a homeopath, you may be a Ayurveda. So I think it's important that you practice what you have learned. You know, trying to practice modern medicine using what you have learned probably is the problem. So if that can be bridged and you respect your speciality, your training, I'm sure it's going to make a huge difference. And we need that. You need this integration of different, domains of medicine to come together. So that is not happening. And probably that is where things could go wrong. And, we need to look into that.
And when I was doing my physics, which was my weak subject, my teacher told me for any structure to be stable, the base has to be broad and heavy. Here, you are putting an Ayush practitioner who has been trained in Ayurveda, he has been trained in homeopathy. You give him 1 year certification course of allopathy, medicines. That is not enough. Pharmacology, that is not going to be enough. The base is not there. On what basis are you going to treat him? So that is one thing. There is two sides to every story. The access to rural people to access to these allopathy doctors are not there. So Ayush practice is there, is a part of the solution. But presently what the government is trying out is a band-aid approach. I don't see any sense in it.
But don't you think it's a pragmatic solution given the kind of demographic?
It's still a band-aid solution, sir. You're playing with human life, sir. It's a band-aid approach. You start them on medicine, allopathy, or teach them allopathy, na? You can start it from the first year. The next batch of doctors who come out, let them practice allopathy. But presently you cannot do that. You're playing with human lives.
If you want to, that Ayush doctor should practice allopathy, we can change the curriculum as per allopathy at first, second and third year. So it will be better for the future.
So a deeper approach, more planned kind of an approach is needed. All right, fine, all right. So we will now move to something which is also becoming a contentious issue, and that is the arrival of technology and the plethora of problems and complexities it opens up, right? So I'll now address my questions, a couple of them to Mr. Nair, right there. So one of these is telemedicine, right? So telemedicine, Mr. Nair, telemedicine, in fact, Dr. Shrikant, sorry, I'm so sorry. I'm so sorry about that. Dr. Shrikant. So, so telemedicine, it was promoted to expand, access. But what it has expanded is also exposure. We have spoken about digital evidence and everything else, right? So, do you think the current telemedicine guidelines are they adequate to protect doctors who especially are acting in good faith? Or are they not? Or some other approach is needed to
So the idea behind telemedicine, it came up during the COVID crisis.
Right.
IMS used to be very scared to promote this telemedicine because there were so many, we knew this issue are going to come up.
Right.
But then it was taken out of their hand because COVID, everybody is quarantined and telemedicine came into the picture.
Right.
The problem with telemedicine, it is supposed to increase the access of patients to medicine. But what practically I have seen, it is not helping out patients. In the sense that the rural people are not aware of it. And the biggest problem with telemedicine is the doctors are not aware of the rules of telemedicine. The first big rule of the doctor-patient relationship has to be confirmed. You should know the identity of the patient knows your identity and you're just going to confirm it. But you should be very sure about the identity of the patient. I have seen many doctors, they just know the name, they know the other, you don't even know what is, and you're talking to somebody whom you're not even aware of. How many people identify the photo of the gentleman with the photo of the other? It's not practically possible. There are practical problems and it is being misused because of that. Because doctors themselves are not aware of the rules of telemedicine. Otherwise, it's a very good tool. And secondly, human touch always works. The touch of a doctor, I've seen even during COVID, patients used to come to the doctor after 2 days of telemedicine. The human touch and the doctor's stethoscope touching the patient is confirmatory that he's okay. The human touch factor is important. Supposing it's far off, you're not accessible, you don't have a choice, that's a different. See, you can't make medicine to be a Swiggy and a Zomato. It has to be, people, I've seen, I got somebody who said your clinics are crowded, so we can, but accept it. But something cannot be told on the, telephone or on video calling. So these Swiggy and Zomato approaches cannot work in medicine.
Nair has come.
Yeah, I have a different approach. So in a remote area, wherein they may not have access to high-end medical care, I think this would definitely work. If the rules are put in properly, if doctors are really trained, there is a training program actually. To actually use that, you have to go through certain guidelines. If that is really taught to them and they are, trained adequately, it can be a great tool. But has to be applied rightly. So for instance, in a primary health center, a medical officer there can have access to a higher center wherein he connects his patient for higher care. So there is a doctor's touch because you have the doctor sitting there. It's only for that extra care which otherwise the patient may not be able to go. So I think it does have a role. Yep.
No, my problem is doctor-doctor relationship is fine. My problem is doctor-patient relationship in a rural area. That is the problem. It should have grown multifold to what it is there today. But the doctor-patient relationship is a problem. A doctor-doctor relationship is wonderful. Primary healthcare doctor is there, he's having the patient in front. That's a good relationship. My problem happens when that gentleman is sitting at home and he's having a MI, then what? So that problem is that because you don't know. And what documents are we talking of? See, telemedicine, the first rule, the doctor-patient relationship has to be established, confirmed. That part, otherwise it's a wonderful tool. It improves the access of patients to medical care, better medical care.
It was touted as an innovation, but the fact that I don't think it has worked very well.
See, IMA has accepted it reluctantly during COVID. Because these problems we knew is going to happen. Yeah.
Yes.
Implementation is an issue. Implementation is an issue. You should have training programs for that, including patients.
E-Sanjeevani, yes.
E-Sanjeevani portal is there, so patients have access to use the telemedicine for this thing. But if we are considering the small diseases like cough, etc., which is our common diseases that we can treat on telemedicine, but for severe, just as MI bola, for that we need to the patient direct consultation from the doctor.
Yes. No, but my question also is, what does it do to the liability landscape, this kind of a development for doctors?
I think the court cases are not, we don't have any recent case. I can only quote judgments if you have, and I don't see anything in the horizon right now. But future is bleak if you start to. I said, the question is awareness. The question is, have you established the doctor-patient relationship and confirmed it? This is a big problem here. This is a area of concern. And then treating the patient, then it's a call you take. What do you do? Should I treat the patient despite being an emergency? Tomorrow he may say, you should have sent me to a hospital. But your hospital is 50 kilometers away. So the best thing next to that hospital, I am God for you. So those are issues which has to be resolved.
Right. So another contentious question to you only is about the emerging nature of evidence, the digital evidence that is now up and coming, whether it is as per the Indian Evidence Act or not. Courts are taking that into cognizance, right? For example, CCTV footage, audio recordings, device-generated logs and all of this, right? Are our evidentiary laws equipped to address this? Or will be prone then to misuse and
See, the law is very clear. Consent has to be written. Now, you get biased. The courts, some consumer courts are biased based on the CCTVs and video recording, which is going to be commonly there. But when it comes to a court of law, tomorrow what the judgments are, it's got to be awaited. Now, we are talking of CCTVs, we are talking of audio evidence, we are talking of it. How reliable are they? Today we are talking AI, your head can be fitted into somebody else's body. How do you go proving it is fake? So there are two sides to every story, so it will depend now.
Right.
To become law, it has to be, how much of value it will be in the future, we don't know. Right. But presently there are no judgments which say that is acceptable in a court of law. Summary trials, everything is acceptable, many things are bypassed. That's because you have got quick justice system. But tomorrow you don't know.
And maybe they're leaning more towards the consumers because they are consumers.
Yes. It's quicker. You get quicker justice there.
Just a small interjection here. In my view, nature of evidence is not problematic. Appreciation of evidence is problematic. Evidence law is not everything about evidence. It's just for the civil procedure, criminal procedure. Say, for example, arbitration also, evidence does not apply. There are thousands of laws where Evidence Act does not apply, right? So it's not everything, it's a very small piece in our justice system. Should we borrow the standards of admissibility from there is a very debatable issue. What Mr. Advocate Bajpayee's presentation was showing was that there are prejudicial things which are coming up from the evidence and they are being considered. So that's an issue of appreciation. Now, there is a fundamental rule of evidence. If the prejudicial value of evidence is more than its probative value, then that evidence should be avoided, irrespective of which law of evidence you are applying. So the difficulties of appreciation and not of the nature of evidence, not whether it is admissible or not. Thank you.
So now we move a little bit towards public policy and regulations, and for that I'll have a few questions to ask Dr. Nair, right? So, we have also witnessed misuse of government healthcare schemes, despite Aadhaar linkages and all of this, right? So, what do you think about this? Is it a technology failure that we must address? Is it an enforcement failure or a governance failure? And what should be done about that? Should courts step in? Should any other mechanisms be devised for this?
Yeah. So, I don't think it's a technology failure. If you look at our Aadhaar and our digital health systems, they're all pretty strong. They're good. But of course, there can be, considering the amount of loopholes there are in technology, it's bound to happen. You will have all kinds of, people and fraudsters and problems coming in. So I think it's essentially a governance issue. How do you tackle this? What are the penalties that you put for people who have broken, the systems and who have? I don't think we have that very clearly put. So people don't get really, caught easily enough. They don't get punished enough. So all of these kind of deviates, from the main issue. So I would say it's more of governance. And as for should the judiciary come in, I would say in a structured way, probably, in bringing about, accountability, in bringing about making sure transparency. How do you, the confidentiality, those kind of things, perhaps. But in terms of, the other operational issues, I would say leave it to the experts because they are the ones who should be doing it.
Or a similar issue persists with registration with the National Medical Commission, right? Oh. Despite the fact that law is very clear on this, right? So where exactly is that failure lying? Administrative capacity, bureaucratic discretion, system design, where is that lying?
Yeah. I think everything. So let me tell you, I think I have multiple registrations. I've registered in various states because when you move from one state to the other, you're expected to register if you want to practice. And so, this goes on. So this has they have tried to change this with the National Medical Registry. They said that one registration for all. But however, the problem is the interoperability, moving from seamlessly from one state to the national, it's not happening because we have not really, kind of designed it well. So some of the state councils are tech savvy and very good, but some are not. So there are problems. So this kind of seamless connectivity is not there. So there has been a huge delay in that. So there's a systemic failure there. And then, of course, shortage of people. So if you put in a query, you're waiting for it. It takes years for them to respond to it because there are not enough people to respond. It's very, very slow process. And finally, if there's any change, suppose your name in the Aadhaar, everything has to be connected. And it's again a manual process. They're not easily taking it from what has already been given. Offline. So it's a huge issue. So then that takes all the time. So huge amount of bureaucratic hurdle. So frankly, I haven't done a national medical registration. So I think it's the same case with a lot of people. So I don't know. I think it's a failed effort as of now. It really needs to be. Yes.
Previously, it was very clear you have to be registered with the state medical council if you are practicing in the state. West Bengal, there was a judgment where I think 3 months or 4 months back, there's a judgment, a diabetologist treating a patient. He had international degrees, but he was registered as an MBBS practitioner. And the court did not hold the doctor liable because he has got the experience based on the degrees which he had not registered it. So this is one dichotomy which you cannot understand because you can take it both ways. So let's see what happens in appeal now.
All right. Fine. So we are almost coming to the close of discussion. As a last question, I would like to address this to Professor Balyan also, right? So also the doctor-patient relationship was a complex one always. With the advent of hospitals, especially super specialty hospitals, the doctor-patient hospital relationship or doctor-patient medical establishment relationship is getting even more complicated, right? In that context, what you're seeing from a criminal law perspective, since you're an expert of criminal law, how does vicarious liability operate in medical negligence cases, keeping in mind this particular scenario?
The law is very simple. Vicarious liability does not apply in criminal cases. That's the bottom line. As far as corporate criminal liability is concerned, if you are aware of the corporate law, there could be a vicarious liability. So it depends upon statute to statute. So there are some statutes wherein a joint effort is required. So as far as those statutes are concerned, there could be a vicarious liability. Now the problematic part is that we are witnessing a rise of cases under BNS where vicarious liability is being invoked. That is where the problematic part is. It is very much like those matrimonial cases that there is a case of cruelty, entire family has been framed. So the similar pattern we see here. Doctor is framed, hospital, administrators, everybody is framed in those cases, and generally speaking, as also evidenced by the report of Advocate Bajpai, whenever those matters are going to the court, they are getting quashed. Police should take a care in making sure that when they are doing preliminary inquiry, they do not name those people who are uninvolved. Usually there is a control test which is also there, whether a doctor who acted, was he acting in his independent capacity or was there a control of the hospital management. If there was a control of the hospital management because of which negligence has happened, obviously there would be a liability. So we also need to look at different spectrum of cases. Some cases wherein ICU room was not provided. There were some cases where access to hospital was not given. So labeling all of them, because I've seen some reports, it label all of them, all the cases against hospital staff and management as vicarious liability. No. Those are what we say individual liability cases, because as a hospital they approached you, you denied entry, now a case has been filed. So that has to be answered individually. So all those who were involved in that particular denial of access to the healthcare facility could be booked. As far as clinical diagnosis is concerned, unless there's an intervention of the management, they cannot be held liable. As far as non-availability of machinery is concerned, machineries are not good, or they are not available, or they are defective. In those cases also, because now they have some role to play in the entire system, there could be some liability. So it also then depend on the case-to-case basis that what exactly was the issue at hand. But bottom line is, and whenever usually what is happening, we are using joint liability interchangeably with vicarious liability. There are many cases of joint liability. Not hospital administrator in criminal law is not charged because of respondent superior. Because respondent superior is a concept in civil law where a superior person who has the deep pockets can pay. In criminal law, they are charged because the patient thinks they are jointly liable. There is some kind of concerted action, conspiracy, common intention, which is available. In the absence of them, all such cases would fall.
There is a practical problem nowadays which we see. midway through the trial, the patient has withdrawn the patient has withdrawn the case against the doctor, and the hospital is left holding the baby. So this is another practical problem which is going on nowadays. So that problem, I don't know how to answer that, whatever be the reasons.
Interesting observation. That. All right, so that brings us to an end of this discussion, right? We've discussed quite a few issues. Lots of issues have not been discussed due to positive time and everything else. If the panel allows, I would like to open the floor for a couple of questions, maybe 5 minutes, and then maybe we can take two or three questions if there are some. Or else we, yes.
You had raised a point, there is early redressal is required, because doctors, over a period of time, doctor also dies and patient also dies. The case goes on. So what is, in my mind, came as the tribunals are there for the other laws. Can tribunal concept be brought in future?
This
can be done?
This suggestion has been there. We have attended a few of the things. Medical legal law should be held separately. Yes. I mean, tribunals for medical legal law, doctors should be held separately, so that's quick redressal. And by the way, I'm Srikant Shetty. Shishi Shetty is not my name. My father has named me differently.
I'm fumbling, including myself with your names today.
Anyway, what I said, that's a good idea.
Yes.
That will be quick redressal. Here the cases, with all those appeals, it goes on to 14, 15 years. And if it goes to the Supreme Court, it's another 10 years. Yes. So the question is it, I don't know. There's no answer to that. The government has to think about it. In fact, all the stakeholders have to think about what to do and how to go about it.
Also, there are classical problems associated with tribunalization, no? The fate of other tribunals.
When it comes to income tax, we have tribunals, so many. But why not for medical legal law? In France, they have government cases, they have separate tribunals for that.
Yes. What can be done to...
That our IMS and I and me talking, you talking cannot help. Na? IMS have to think about it.
I'm asking what we can do to get the tribunal.
Tell the IMS whom we are going to be electing next month, it's in litigation. So next time you tell them this is what you should be talking.
Yes, but Professor Chirag will also add to that, but tribunals have their own share of problems. Right?
So that's what I was about to say. The idea of tribunals in India have failed. There is a parliamentary standing committee report. Mostly the government is trying to wind them up wherever they have created. So, and you are concerned with a criminal notice or other kind of case notices. More tribunal means more cases. It's as simple as that. It means more access. So is that really an answer? We need to ask ourselves. But tribunals have not stood the test of time as far as our country is concerned. There is a 2023 tribunal bill also which is pending. The constitutionality is pending.
Also, most of these cases still end up going to the High Courts and Supreme Courts in the longer run. Right?
It's a layer to the case.
Right. So, yes, please. Yes.
It's okay, we have a small hall. So my question is, having more medical legal cases is good for future? The status quo as it is good? Or we should aim for having less cases? I know awareness and multiple questions have already been discussed. So my question to the panel is that in future, see, the population is 142 crores. It's going to definitely go higher up. We are getting educated. There are ChatGPTs, there's AI. Everybody is knowing what is happening, and we're expecting more and more number of cases. So scenario for India, we're talking of so many deals and this and that. So the cases would definitely increase. So it will be good to have more number of cases. People are aware. It will be good that make them more aware so that both parties are aware and they have standardized the understanding and we try to optimize it or continue as it is.
See, the checks and balances have to be there. You can't let somebody loose on the... we are basically talking of human bodies. But the question is, are the judgments fair? That is what we want. Is the process of law more tortuous than the law itself? These are the issues which should be resolved. We should have it. Law should be there. There should be checks and this is basically for patient safety. So they have to be, you have to have rules there. But is the judgment going to be fair? Is it going to be biased? You can see many judgments, they are not fair to the doctors. I always say, if it is a bad judgment, then the lawyer was bad. If it is a bad lawyer, it's a doctor's mistake. Whom do you employ? You get a good lawyer, no? You got a cheap lawyer. And who is a lawyer? He's an officer of the court who helps the court arrive at the correct decision. If the judgment is against the doctor, means that the lawyer has not helped him. So that the judgment has to be fair. Checks and balances have to be there for anything.
All right. So yes, ma'am. One final question I think you'll take.
The basic thing, it may not be dependent on the evidence and other thing. This is totally because of the common access to the technology and Google's. Many patients, the patient comes and they dictate this is my diagnosis and give that particular treatment. So what is the question of examination and investigations? That is something, and if the patient comes with some intention, they might go to the criminal court, patient, doctor has not examined the patient. What are you talking about the patients and questions? So I think possibly it is because of the enormous increase in population and very easy access to the technology. That is the thing. And first thing, there is a question of consent. So consent usually, doctor and sister, we write in an English one. To the Maharashtrian, then you write in Marathi. Suppose by chance you get a patient from other South Indian other thing. Neither nurses, neither doctor, they are capable of understanding the South Indian language. Then they think we should give the consent in the term that the patient should understand what is the consent. And not only they should provide the interpreter in something like a political issue or something like that. Yes, so we are going to be trouble like anything. And as a doctor, we always harbor some evidence of fearfulness. Because it's the cost of our losing our career and nothing. It is, thank God, I myself, I finished my career, but it is it is no longer lucrative issue as a career of doctor. I think this is enough for me.
That's coming straight from the heart.
Part of the career is, I think, long lost gone.
Yeah.
That part is gone.
So those days are gone. Now
as far as your consent, there are rules of consent are there. As far as the language goes, there's a rule of consent. I mean, so those rules have to be followed. There's no shortcut for consent.
But sometimes you can have a not 100%.
The biggest problem is once upon a time a doctor's word was gospel. Today, before he goes out, he would have checked up what are, Justice Thailiani said, I go home and check up on Chat GPT. And a judge himself does it. What are we talking of? Artificial intelligence is exposed to law. Awareness is become better, so your respect has gone down because awareness is better. Previously, you are God. Now you are on equal terms with the patient. Now it's a contract. You are a service provider, he is a customer. So let's accept the fact. Now let's move on. That is progress.
All right, ma'am, I think that would be it. And on this note, we can close the discussion in the interest of time. I thank my panelists, Dr. Swati, Dr. Shrikant, Dr. Balyan, and Dr. Nair for such a meaningful discussion and fruitful discussion, right? I do sincerely hope that the discussion will go on in other settings, institutional settings, courtroom settings, and all of that, and we will be probably in a better position than we are today. Thank you very much. And also must thank the audience for their patient hearing, for staying back till the very end. Thank you.
Thank you all the panelists for such a wonderful discussion. We are honored to have as our guest of honor Ms. Viveka Roy Chaudhary ma'am, a veteran journalist with nearly 2 decades of expertise in pharmaceutical and science communications, an alumna of XIC Mumbai with a background in microbiology and biochemistry. She has shaped the industry narrative through her leadership at the Financial Express and Pharma Bio World. A dedicated educator and editor, she remains a vital voice in bridging the gap between complex science and public understanding. We are now honored to hear from our guest of honor, Ms. Viveka Roy Chaudhary ma'am, the distinguished editor of Express Pharma.
Good evening, and thank you to the audience that has remained back. But thank you so much, Advocate Bajpai, Mr. Ravindra Mangal, for inviting me for such a very insightful sessions, very insightful discussions. I have made some of my comments as part of the panel discussion. I want to leave this audience with the thought that this needs to be a more transparent process to build on the trust deficit, to, the trust between the doctor, between the patient has eroded quite a lot. And as many speakers have said, today all patients, me included as a journalist, we Google, we go on Claude, we go on Gemini, Justice Tahiliani too does the same. So a doctor is dealing not just with an impatient patient, but with a patient who thinks he's a doctor himself. And very soon that is going to happen with the legal profession as well. Because legal assistants are being replaced again by ChatGPT. So you are going to have a patient who's going to come to you who has Googled his medicines, who has Googled his legal course of action too. So patients are already going to come to doctors and threaten them that if you don't do this and this happens, this is what I'm going to do. I'm going to sue you. I'm going to prosecute you. It is happening, and it's all happening because of the trust deficit which is not there. I would urge the Institute of Medicine and Law and the DY Patil, it's wonderful that they are collaborating, and I hope that with Express Pharma and the Indian Express to back me, I have my colleague from Indian Express, Purnima, here, who's also filing her report. I think more journalists need to be brought into this conversation. What is also I found missing here, just as feedback to the organizers and possibly in other subsequent programs, maybe patient representatives. I'm purposely not using the term patient activists, because there are some very responsible patient organizations which can be made part of this conversation to sensitize. When you talk about sensitizing the police in filing FIRs, etc., also sensitizing patient organizations and patients themselves who can talk about these things. It's wonderful to see a lot of doctors also as lawyers, because I think that serves the purpose of, let's face it, it's defensive medicine that is out there, and which is why a doctor prescribes a lot of, diagnostic tests, because he's always thinking that how can I, save my practice and, practice responsibly and, be defensive about the way I practice. So those are my thoughts, and a line that struck me was that law is not a hurdle for healing, but a guardian of both the patient and the doctor. I think for me that is really an affirmation, and something that I would like to emphasize in my coverage of this event, in the way that I cover these kind of topics later. So this is going to inform the stories that I write. I'm sure Purnima also will go with that message and a lot more. Please, involve more journalists and make us part of the conversation as well. And anything that, can improve trust is going to really, reduce the number of cases and the number of, and the amount of conflict. As one of the panelists says, conflict is good, because then you kind of refine and you reform. Without conflict, you're not going to refine, you're not going to reform, and you're going to actually regress. So with those few words, once again, thank you so much for calling me for this, and look forward to more such discussions. Thank you.
Thank you so much, ma'am. As we draw this insightful session to a close, I would like to invite Mr. Ravindra Mangal, sir, to propose the vote of thanks.
Distinguished guests, learned colleagues, and all our partners in the medico-legal domain, a very good evening to all of you. On behalf of the Institute of Medicine and Law, it is a privilege to offer this formal vote of thanks as we conclude the 18th Annual MedLegal Review 2026. We are deeply honored by the presence of our chief guest, Justice M.L. Tahiliani ji. His thoughts and deep insights have provided us with the much needed legal clarity that the medical community strives for. Our sincere thanks to Ms. Viveka Roy Chaudhary the guest of honor for this event. As the editor of Express Pharma, your participation underscores the wide-reaching impact of medico-legal standards in the healthcare industry. A very special note of gratitude to Professor Dr. Karuna Malviya, Director of D.Y. Patil School of Law. We deeply value the partnership with your esteemed university and thank you for chairing this session. We also extend our gratitude to our keynote speaker, Advocate Mr. Mahendra Kumar Bajpai. Your dedication and expertise in medical laws continues to be a guiding light for the entire healthcare fraternity. To our esteemed panelists, Dr. Suman Iyer, Director, D.Y. Patil School of Public Health, Dr. Swati Sonavne, HOD of Forensic Medicine, D.Y. Patil School of Medicine, Dr. Chirag Balian, Associate Professor, D.Y. Patil School of Law, and Dr. Shrikant Shetty, Editor of Medical Law Cases for Doctors. Thank you all for your time and the depth of your research. You have truly brought the evidence-based aspect of our motto to life. We would also like to thank Dr. Amit Kumar from MNLU for his expert moderation, ensuring a balanced and insightful discussion. Behind every successful review is a dedicated team. I would also like to thank the technical and administrative staff of both Institute of Medicine and Law and the D.Y. Patil University, as well as all the student volunteers who have worked tirelessly behind the scenes. Finally, to our audience, doctors, lawyers, and students, thank you for your commitment to MedLegal excellence. At the Institute of Medicine and Law, we believe that informed professionals lead to a safer healthcare system. I have reserved a special note of thanks for our esteemed associate, Dr. Chirag Balian, for his untiring efforts and dedication in putting this wonderful program together. On a very short notice, this would not have been possible without you. Thank you all, and have a wonderful evening.
Thank you, sir. I request all to please rise for our national anthem.
गण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request all to please proceed to the first floor banquet for the high tea.